Salty, go away. Ben, this seems to be,
Just the first slide.
it seems to be, we're gonna, did you not have,
Just pick it up again.
you can't resend them, no?
Oh, I can,
Oh,
yeah,
do we?
I can resend it.
Render, that would be, let me just, hold on.
I'll just resend it to your email.
I'm just wondering, how do I get access to it? I have not done this before, except, no, that won't work. Strange. So what are we actually missing?
Yeah, that's that.
Is that, and maybe, that's all?
Yes.
I'll tell you what we'll do. I'll tell you what we can do. We just basically cheat a bit and we'll just add it. Okay. Now the address is important. So we put that.
Shall I do it?
Yeah, you do it. You type, just type it, because if this is the only one that we're missing,
I'll put the
we're okay. Hello. And we've got, that's important, that one there. Then we have to save it. Make sure you, which is the way up there. And get your email in as well.
Yeah, got it.
Oh, you saved it?
Yep.
Okay.
Oh, save it, save it.
Make sure you saved it. Okay, because
Because it clicks.
what I'm going to do is I'm going to try. I may have to fiddle about with this to try and if we turn it off. And then we turn it on again.
Do I need to save it in a certain place, or is that just click save?
I think you're fine at the moment because no, just save it. Right, here we are. Now, hopefully this time it will work. Yep, bingo.
Oh well.
Good. Excellent. I have no idea what I'm doing, but it's, this is what Einstein used to say.
Yeah.
I know I'm doing research, but I don't know what I'm doing. I wonder why we're getting... right. Excellent. Incredible. Get a prize for this. Okie dokie. Now, right. I think that people drift in because a lot of them are at Mile End. So it's inconvenient for them to be here, but it's very convenient for us because Mile End's too far away. So my colleague who co-teaches, Douglas, who's sometimes here and sometimes not, he prefers it here. So basically, what we do, we'll. This is the microphone here. See, it's the sort of thing you can put. You can either put here, or you can have it down here. You don't. But up to you. Whatever. When I introduce you, what am I going to be saying? On the Board of Trustees of the Charter Institute.
Chair.
Chair. That's very important. Wow. No wonder you've got so much work. Really. And then
Independent arbitrator.
independent arbitrator.
I've worked at major law firms for the past 30 years as a dispute official.
As a dispute specialist.
Yeah.
Okay. You don't want me to mention any specific law firm now.
I was at Ashurst, Mishcon, and then I was at Foxley. Very lovely.
Okay. Good. All right.
Can I just check on timing? So I'll go for about an hour and a half.
Oh, take your time. Take it. Oh yeah. Look, you'll find levels are different in the room.
Yeah.
So the stories will be good, and inviting questions will be good, because then you get more of a feel about what they know and what they don't know. Take your time, see how it goes. I mean, I think you're not going to be bound by the slides anyway, are you? No. Good. And before we've had a guest speaker, it's all gone very smoothly, and they engage as well, so it should be. I mean, all the postgraduates, they've often come with some work experience, so they're from their different countries.
Yeah.
The overwhelming majority are from outside Europe. So quite a few from Asia, but also from West Asia as well. There's some Indian subcontinent.
I'm half Indian. I'm half Indian.
Right.
Yeah, my father's family is from India.
Oh, well, there you are.
Yeah.
Okay. Today we're going to be going over the subject of dispute resolution, and so I want to begin by making a request which has nothing to do with dispute resolution, but it's heavily to do with the fact that I suddenly find myself without my telephone charger. I'm just wondering, does anybody here have a charger that's going to temporarily share with me? I promise I'll give it back to you. My phone is very low. Well. We don't want to hear Okay, problem solved. As you see, I'm human too. So, anyway, today what we're going to do is we're going to have a look at dispute resolution. Now, this is quite a complicated subject, extraordinarily important, and it's important for you to be aware of it for two reasons. One, it plays such an important part in international commercial transactions. Always that possibility of a dispute taking place, which you hope it won't, but you have to get ready for it before it happens, because once it happens, the relations between the parties will be very, very different, and people will not be very cooperative. So you have to think ahead to the possibility of a breakdown. And what would you do? And how would you address the dispute if it does happen? So the dispute, remember, is once it happens, it's likely to stop the business going forward. And so what you'll find is that during that time, somebody, and possibly both parties, are losing money, and they're going to be very, very angry about all this. Now, so the reason is that it's important. That's the first reason. The second reason why it's important is there's so many disputes in the world that some of you may wish to become dispute specialists. Now, that's not a bad career choice, okay? So it doesn't mean that you're a bad person because you're focusing on disputes, okay? It's just a job, but it's a kind of a direction to take as opposed to, say, transactions. You may want to do both, but it may suit you temperamentally to be going towards the dispute side, or it may just be something you're very, very interested in. Okay, so disputes is for both those reasons: the practical, the more personal side, but also the practical, professional side of international commercial law. It's very important to focus on disputes. So today's class is only about dispute settlement. And some of you will be wondering, well, are we going to be talking about arbitration? Yes. Are we going to be talking about litigation? Well, in relation to arbitration, yes. Why is it that arbitration is so often favored over and above litigation? Why? So that's one of the things. It's all right. I was really starting. It's just me doing some introducing. So basically, that's something to keep in mind: the relationship between arbitration and courts, which is maybe becoming a little bit more of a hot topic at the moment than it's been for in the past. So anyway, I wanted to talk about this, but I realized that probably the best thing for me to do is to send you an outline, which I've put on the website. I've also sent you a reading list as well. And then the other thing I want to do, make this, yes, that's fine. The other thing I thought I would do is invite somebody who knows a lot more than me to come along and talk about arbitral principles and practice. So I've invited Ben Giretta, who has spent many years working in different law firms, and including a period of time geographically not working in London but working in Singapore. So he's practiced in a number of different places. But most importantly, he's been in charge of disputes in those law firms. And so he has a lot of experience as a specialist in dispute resolution. And most importantly of all, there is a body called the Chartered Institute of Arbitrators, which some of you may have heard of, and which you should think about joining if you want to try and get into the junior side of it. It's a very good way of networking with young arbitrators, junior arbitrators, arbitrators to be all around the world. And so it's a really good, and it's a genuinely international network. So you should think about that. But Ben is actually the chair of the board of trustees behind the Chartered Institute. So he can tell you quite a lot about that. And it's quite a useful, it has a number of courses that will allow you to become recognized as an arbitrator. You can do a diploma. I'm not trying to promote it, but I did do it myself some years ago. And I found it was a lot of hard work, very intensive, but it was a very good course that I did all those years ago, and I learned a lot. So Ben has got a few slides, but I think you should keep in mind that because he's here, and he's here in person, not virtually, he's not a hologram, he's genuinely here. Because he's here, you should feel free to ask him questions. So he's not going to mind if you ask questions, and when we have an intermission, you're very welcome to come and have a chat with him and ask him questions directly. So keep in mind, please don't be shy. He'd be very happy to talk to any of you who want to talk to him. Remember, I'm very committed to networking because we're in London, and that means networking for you and our guests. Okay? That's important. That's part of your added value to being here at Queen Mary. And I should also say that Ben is an alumnus of Queen Mary University himself. So some years ago, maybe not long ago,
2003.
Was a student here at Queen Mary. So he is also a kind of an indication of an indicator of what you can become if you've got a qualification in commercial law here from Queen Mary. So with all those words of introduction, I'm going to hand over to Ben and also say thank you, Ben, for coming to share your thoughts, and no doubt all the stories that you will be able to, all the anecdotes that you will be able in confidence to share with our students this evening. So, Ben Giuretta.
Thank you very much. Is it too loud? Might be a bit loud, haven't we? Something might have to put it down. Can people hear me? Okay, so thank you, everyone. Thank you for Peter, that introduction. My name is Ben Giuretta. About 20 years ago, 2003 to 2004, I did the postgraduate diploma in international arbitration at Queen Mary, which was half the LLM. So I've sat where you're sitting now, albeit I didn't sit here in this building. We did lectures across Chattow Square in St. Bart's and also at Russell Square, but it's all changed since then. But it's 20 years ago that I did that. As Peter said, that I'm a disputes lawyer. I've been working in disputes since 1999. I'm now an independent arbitrator. Thank you very much. And I'm also the chair of the Board of Trustees of the Chartered Institute of Arbitrators. What I'm going to do tonight is talk about dispute resolution methods. I'll talk a bit about the theory behind them, talk a bit about the law, and also talk quite a lot about my experiences. I must stress, when I talk about my experiences, you must not take notes. This is all Chatham House rules, as they say, all between us. So please do not record me when I'm criticizing my clients or slagging off people or whatever. Now, as I go along, I'm very happy to take questions. I mean, to be honest with you, I'm much happier to answer people's questions than I am to talk about slides. And I should also warn you, I'm terrible about timekeeping. I may well just go on and on and on, so you may have to stop me at some point. But let's see how we go. As Peter said, I've had a long career in dispute resolution. I've mostly done arbitration. We did a book recently on the Arbitration Act. That's my name on the book. Please do go out and buy it. It's the Arbitration Act 1996, a commentary, all 700 pages, commentary on the Arbitration Act. Okay, so what am I going to talk about today? Oh, sorry. Slide, sorry. So I'll talk about types of dispute resolution. I'll talk about the arbitration process. I'll talk a bit about the Chartered Institute arbitrators, and then we'll have Q at the end. But as I said, questions at any time as I go through it. Don't wait until the end, but we'll also have a Q&A session at the end. So, the types of dispute resolution. Well, why do we need dispute resolution? There's a few thoughts up there on the screen. Firstly, we need dispute resolution in law because contract clauses very often are open-ended. In the process of negotiating a commercial contract, it's not perfect. Very often you get to points where you just simply cannot agree things, and therefore you leave it open. For example, you might have a clause which says the parties must act in good faith to do something, because they can't pin down exactly what they have to do. They might leave it open what the price is going to be in the future. For example, under LNG contracts, you often have a fixed price now, but a mechanism to change the price in the future. You might have force majeure as well. Something might happen outside the contract, and therefore you've got to change the contract. So, and when those things happen, you're likely to get a dispute between parties over what the way forward is. I was pausing there because I was thinking about experience I had with LNG contracts in Australia, which all involved force majeure. I'll come back to that in a second. It's very, very interesting. I had a lot of experience over that. You also need dispute resolution because of people make mistakes. People also misunderstand things. The world is not a rational place, or not entirely rational. The law is not a rational process, or not entirely rational. There's always going to be some people who don't listen. There are always going to be people who don't understand. There are always going to be people who act irrationally. And therefore, at some point in a long-term contract in particular, you're likely to have the need for dispute resolution. There may also be unexpected events. I mean, look what's happening now in Iran. I bet you when people signed contracts involving tankers going through the Straits of Hormuz 5 years ago, they didn't predict what's happening today. And therefore, they've got to resolve that in some way. And finally, people breach contracts. It's a fact of life. You can draft a perfect contract, but at some point, someone may say, no, I want to breach the contract. I want to walk away from it for all sorts of reasons. I had a contract which a client came to me and said, well, I'm paying too much under this contract, and I want to breach it. So how much would I have to pay in damages to walk away? And they did. They walked away from it because it was worth more to them to walk away than to stay in the contract. And that, again, is a fact of life. People don't comply with contracts. So what ways can we resolve disputes? Oh, my slides have frozen already. Well, the obvious way, the basic way that people all know, the way that you've talked about on your courses, I'm sure, is the courts. And what we're talking about here is national courts, the courts of India, the courts of Japan, the courts of England, the courts of wherever. They're national institutions, paid for by governments. So the courts here, for example, there's a budget, comes out of the national budget. Judges all paid for by the government. And are also organized by the state as well. So each state sets its own rules about what happens in those courts. Each state appoints the decision maker, as I said, appoints the judge. The jurisdiction of the courts also covers the whole country. It also can cover people who are nationals of that country. For example, the Bribery Act in England, that covers UK citizens bribing people outside of the UK. So that's an example of something where the courts have jurisdiction in England, even though the act happens outside the UK. But mostly, jurisdiction is defined by what happens within this country. And that's very broad, but it's also very limited. If you have a breach of contract here, or you breach the law here, you go to the courts. But you got the same breach of contract and take that to France, you couldn't come to the English courts. You'd have to go to the French courts, for example. The courts also involved a closed group of people. If you go to the courts, you'll find there is a particular group who run those courts. They're the judges, they're the court clerks, they're the lawyers who appear in those courts. You cannot have people wandering off the streets to take part in that process. There are strict rules about who could be part of that court process. And it doesn't, I'm making these comments about the English courts, but this applies across the board, whether you're in the courts of India or courts of Japan or wherever. We're also talking about courts which operate under a certain culture. The culture in England is different from the culture in France, for example. The language is different. If you take a breach of contract matter from the English courts and then you take it to the French courts, you'll have a very different experience. The principles may be very similar. Lots of commercial laws throughout the world are very similar. The results of the breach of contract may be similar at the end of the day, but it'll be a very different experience. You'll be dealing with different types of lawyers. You'll be dealing with different types of judges. You'll be dealing in a different language. And this process, this experience, is very important. So it's not just about what the result is at the end of the day, but also about what the experience is for the clients. I had a case a while ago which actually did involve Iran. It involved the sale of metal copper to Iran. This is a very long time ago, nothing to do with the situation today. And there was a fraud involved. Our client was a Swiss company, and there was an Iranian involved, and there were some other parties involved as well. Now that case involves some very complicated areas of English law, particularly related to what they call quasi-contracts in English law, or unjust enrichment. Now that question about unjust enrichment went from the High Court to the Court of Appeal up to then the House of Lords, as it was called in those days. And at the end of the process, our client came out of it not only to pay damages, but they have to pay a lot of costs. And the first thing that my client said to me when we came out of the final courtroom was, well, I'm very pleased you got that result for me because we don't have to pay these millions of pounds. On the other hand, I've had a terrible experience because I spent years going through this process. And at the end of the day, I've got to pay a lot of costs. So the process is important to people just as much as the outcome. The courts are often called a public process with public effect. Now that should be obvious. It should be obvious we're talking about a public process. That means that anyone could come along. There's a principle of open justice in the English courts. So anyone can wander in off the courts and sit off the street, sit at the back of the courtroom and watch. It's public. Obviously, there are some circumstances in which a process might be private, particularly when you're talking about some criminal matters, some matters involving confidential information. The courts have the power to restrict access. But the general principle is that it's public. It also has, again, this should be obvious, but it has a public effect. So if you have a judgment, that has effect throughout the jurisdiction. And if you don't comply with the court order, that is a criminal offence. Certainly in England it is, that's a criminal offence. So there are public sanctions behind what the court does. Bear that in mind as we move through these other processes, because it's a very important point. Well, all these points are important, of course. Now let's compare it with arbitration. Arbitration, as I said here, is a private process but with public effect, meaning that it's a process that happens in a private environment. Unlike a court where anyone can wander in and watch, you cannot wander in and watch an arbitration hearing. I was in an arbitration hearing back in February. It took place at the International Dispute Resolution Centre, which is over by St Paul's, and it was a closed room. There were lots of people in the room, but they all had permission to be there. And if someone wandered down the corridor and knocked on the door and said, "Can I come in?" we would have said, "No, you cannot come in." So that's different from the courts. On the other hand, arbitration has a public effect. So like the courts, you can take an arbitration award and make it enforceable. It's not direct, doesn't have directly the same effect as a court judgment. You have to go through various processes in order to get that to that point. But it can get to that point if you follow the right processes. So you could end up with an arbitration award being converted to a court judgment. Funnily enough, the case I just referred you to, the one I did in February, which I'm going to talk about quite a bit more later on, that involved an arbitration award which became a judgment. So we had an arbitration today in 2026, but it was about another arbitration award which had been made way back in 2012. And that had become a court judgment in Hungary at that time, and it had public effect. Private process with public effect. Now, unlike the courts, arbitration is not defined by geography. The courts, as I said, you look at the country in which the courts exist, the national courts. Arbitration, you look at the contract. Every arbitration comes out of an arbitration agreement and a contract. And the jurisdiction of the arbitral tribunal is over that contract. Not over the country, it's over the contract. Now, that has an advantage in that you can take it all the way around the world. You can have this arbitration. You can have the arbitration about something happening in England, but the arbitration could take place in Australia. It could take place in Brazil. It doesn't really matter where it happens. It can take place entirely online. But on the other hand, you don't have the same powers that a court has. A court has the powers across the whole country. A court can order people to do things across the whole country. I could go out and obtain, well, if I was at a contract case currently in the English courts and someone else was held to some vital documents, for example, this person here, if you hold some vital documents, I could get a judge to order her to hand these documents over to me, because the judge in England has jurisdiction over everyone in England. But if I was in arbitration, I could not get that same order, because the arbitrators only have jurisdiction over the contract and over the parties to the contract. But if a third party has those documents, the arbitrator cannot order that person to hand over the documents. There's still a mechanism to obtain these documents, which involves going to the court and asking for support. But the arbitrators themselves do not have the jurisdiction to order third parties to do anything. Arbitration is privately funded, which is good and bad, of course, because it's good in the sense that you get what you pay for. If you want to pay more money, you'll get a better service. On the other hand, it's bad because you have to pay for it. And people complain about arbitration being expensive. Well, it's expensive because you're getting a very good service. On the other hand, people complain about the court system for being underfunded. They're saying that, well, government should put more money into it. They're complaining about the service that they get. Whereas in arbitration, they like the service, but they don't want to pay for it. It's party organized. So an arbitration process is a result of submissions that the parties make to the arbitrators. Sometimes the parties agree on a process that the arbitrators have to follow. I'll come back and talk through the process in a second for some arbitrations. But generally speaking, we have what's called party autonomy in arbitration, which means that the parties set their own rules. Arbitration involves a wider group of people, in the sense that you're not confined to the particular people that courts license. You can have an arbitration taking place in England, for example, and have lawyers from Colombia take part in it. You can have lawyers from Malaysia taking part in it, and they all come to have a hearing in Rome, for example. It can be very international. It's not like the courts where you can only have state-appointed judges and only have state-licensed lawyers. You can also have an appropriate language for the case. So instead of English in the English courts, French in the French courts, for example, you could have an arbitration and choose to have that entirely under Mandarin Chinese, even though the arbitration takes place in New York, for example. You could have the arbitration under Hindi, even though the arbitration takes place in Madrid. You could mix and match a lot more than in the courts. And as I said on the slides, it's an international culture, which means that parties generally work towards having a common approach to the process over things like disclosure of documents, over the way you present your case, over the timetable for the case, which you won't get in a court, because the courts have a very national process with particular rules about how things are run, whereas an international process has been put together by people across the world, and there's generally common ground as to how we should approach these things. I've been speaking for the last 20 minutes, and no one's asked a question yet. Wow. Please.
Sorry, hi. What didn't get which party funds the arbitration, like both parties, or just like the one who calls for the arbitration to get or support?
The principle of 50-50. Now, there's two caveats to that. Firstly, the caveat, what if someone doesn't want to pay? For example, you start an arbitration against me. I don't want to be in this arbitration. You start against me. I'm not going to pay. In which case, the general approach, it depends on the particular rules, but the general approach is you then have to pay for the arbitrators, but you can obtain an arbitration award to force me to pay during the process. So I'm forced to pay my share. The other aspect of that is, generally speaking, arbitrators have the power to award costs at the end of the process. So if you've paid for the arbitration and you win, then the arbitrators, at the end of the process, when they issue their award, will order me to pay damages to you, assume it's a contract breach case, and also order me to reimburse your costs. So at the end of the day, even though you paid up front, you'll get your costs back. Any other questions? Please. There can be, so the question is about language and location. So there can be, you do see contract clauses, arbitration clauses, which are very specific and say what the language is, what the where hearing is going to take place, etc., etc. But equally, you can see arbitration clauses which say dispute shall be referred to arbitration, which is still valid as an arbitration clause. And then the tribunal has to be appointed, and they have to work out what the language is, what the location is, etc., etc. There's a concept called the seat of the arbitration. The seat is the legal place where an arbitration happens. It's not to be confused with the geographical place of the arbitration. So this is very confusing. It's just a legal concept, not a geographical or a physical concept. For example, you can have a seat of arbitration in New York, for example, but the arbitration and the arbitrators never go to New York. They never interact with any New York lawyers. They never have anything to do with the New York courts. So it could be entirely online. And their language could be a language that is not spoken in New York. But it's still, the seat is New York. Now, why is that? The reason is, for two reasons. Firstly, we need to have somewhere to go to if something goes wrong in the process. So what the parties are saying is, when they say the seat is New York, they're saying, if something goes wrong with this process, one of us can go to the New York courts to help. The New York courts have powers to supervise the arbitration. The second reason is there's an international treaty called the New York Convention, which was drawn up in 1958. It is one of the most successful treaties in the world. It's got 175 parties, I think, to it. 175 countries have signed up to it. And it means that you can enforce an arbitration award around the world. You can take an arbitration award made in one country and enforce it in another country. The problem with one of the problems with the New York Convention is that it only applies to foreign awards. And in order to define whether an award is foreign, you need to know where it's come from. And therefore, an arbitration award needs to come from somewhere. So I'm going by my example. If you say the seat is New York, you're saying that the arbitration award, in theory, comes from New York. And then, if you want to take that award out of New York and enforce it in, I don't know, Poland, that will be done on the New York Convention. But if you're going to take that New York award and just enforce it within New York, then the New York Convention doesn't apply. Forgive me, I'm using New York quite a lot there. But if you're going to enforce it domestically, the New York Convention doesn't apply. Or if you're going to enforce it internationally, the New York Convention does apply. Please.
Something which is like the law of arbitration. I'm not sure if this is something common in contracts. Was it even important to add it if we basically just like refer to an arbitration process with arbitration says that they would already have their own policies that the parties should follow the arbitration? So
it's a very good question. It's a very complicated question. So I'll take it slowly. In arbitration, we talk about applicable laws. Laws, plural. There are many laws that are applicable in arbitration. And what is the applicable law depends on what you want to do with it. Depends on the question you're asking. So, you get the example of the law governing the contract. So in that situation, what you're doing is asking yourself, what law applies when you're looking at a question of breach of contract, or a question of interpreting the contract, question anything to do with the contract. And then you look at what the parties have designated as the applicable law. Normally, they do call it the governing law, just because that's just practice. They call it the governing law. However, if you're talking about what happens within the arbitration, that's different. You're not talking about the law applicable to a contract. You're talking about the law applicable to the arbitration. And that could be different. And normally, it's the law of the seat. That's a generalization, but let's not get too complicated. It normally is the law of the sea. Now, on top of that, the arbitration agreement within a overall contract, in theory, stands as a separate, self-standing agreement within the main contract. So if you have a main contract which consists of 50 clauses, and clause 49 is the arbitration agreement. The governing law clause in that contract covers clauses, the other 49 clauses, but doesn't cover clause 49, the arbitration clause. You can have a different law applicable to that arbitration agreement, which tells you how to interpret that arbitration agreement. On top of that, you can also have the law applicable to the arbitrators themselves, because they may come from different countries and they may have different laws applying to how they work. Now we get into details like what tax applies to them, what permits apply to them, what authorities they have potentially. On top of that, you could have the law applied to the parties. This does come up sometimes. Does the law allow this party to enter into the contract, for example, under the local law? There was a case that came out in the English courts a few weeks ago. It was about a container terminal in Egypt. One of the parties said, we are not bound by this arbitration award because under Kuwaiti law, which is where the company comes from, we were not allowed to enter into this arbitration agreement. So even though I think the governing law was English law in that case, they were saying that under our local law, we were not allowed to enter into this arbitration agreement. The judge said, that's ridiculous. This has been going for years. You're now raising this point. No, they were bound. What other laws do you have? You can also talk about the law applicable in the place of enforcement. Sometimes you can think about, well, we have this arbitration award, but we have to ensure that it is enforceable in the place of enforcement in the future. We have to carve it in a certain way. For example, in Indonesia, if anyone here is from Indonesia, I don't think you can make an award which orders someone to comply with a contract. I think that's right. I may have got that wrong. Don't quote me on that. I think you can only order damages in Indonesia rather than an order for specific performance. I may be wrong about that. But you can see what the general principle is. You might have to think ahead about where you're going to enforce the arbitration award. You might seemingly have to think about the law applicable to the arbitration institution. I mean, you can see I'm going on and on and on here. There's lots of applicable laws.
Okay, but if we, assuming, as you said, that it's generally like the law of the seat, if we just said that receipt of arbitration is New York, for example, so this way we're assuming that the law of arbitration is going to be the law for the US.
What-
You
what-
think this might open, I don't know, the window for like further disputes in the future about like the details, or is it not really that important to do that specifically?
Well, so we're talking again about what applies to the arbitration, the law applicable to the arbitration. And you're right that generally it is the law of the sea. Now, what I said, I go back to the question I gave before, the answer I gave before to the previous question. If you designate the seat, you're saying that the courts of that country have supervisory powers over the arbitration. Then the question becomes, what laws is that court going to apply? In theory, the parties could specify different laws. So let's go back to my New York example again. The seat of arbitration is New York. An arbitration is taking place there. But the parties say, we want the law of Peru to apply to this arbitration, which they can do. Certainly, I don't recommend this, but it is possible. So then, but because it's the seat of the arbitration is New York, either party can go to the New York courts and say, please exercise your supervisory powers over this arbitration. Oh, and by the way, please apply the law of Peru when you're doing this. And it may be possible. I think I can pretty much guarantee that however the New York courts do it, they'll generally approach you from a New York law point of view. And generally speaking, will regard Peruvian law as much the same as New York law. But you see, it gets very, very complicated if you start to go down that route, starting to specify different laws. Please, sure.
Basically, the seat is like just if you're location deciding the parties can or cannot meet their resolution there. Or the clause must be saying specifically that if a dispute resolution, like if a dispute arises, it is something that is.
So the parties decide on the dispute resolution method. They decide on litigation, they decide on arbitration, they decide on some of the methods I come to. And then they decide where the process is taking place. So it's that way around. So they decide on arbitration, then they decide the seat of arbitration is New York. Forgive me, I'm going back to New York again and again. It could be any seat. And then after that, they decide what laws to apply to all this. But generally speaking, if you decide on the seat of the law, most parties will accept that means the New York law applies to the process of the arbitration. They might then decide that a different law applies to how you interpret a contract, the governing law of the contract, because they have Venezuelan law or whatever as the law there. But it's that way around that you approach things. Any other questions about difficult points of arbitration law? Not yet. Not yet. Okay, arbitration. Yes, I think I've covered all these points actually. I will come back and talk more about arbitration because this is my specialist subject, and we'll talk about some arbitration processes in a second. But let's look at some other dispute resolution methods first. Mediation. Mediation is not arbitration. Mediation does not involve a decision maker. Mediation is closest to negotiation between the parties. You have a dispute, you want to negotiate it with the other side, you come to an agreement. It's a step beyond that. It involves, you have a dispute, you want to negotiate it with the other side, and you get a third party to help you with that negotiation. You're not asking that third party to decide on the outcome of the dispute, you're asking them to help you reach a settlement. Now that has lots of advantages and lots of disadvantages. Start with the disadvantages. The first disadvantage is that third party has no powers. They cannot order the parties to do anything. They cannot order them to hand over documents, they cannot order them to pay over damages, they cannot order them to attend at all. On the other hand, that third party has a very broad sort of very broad mandate to speak to the parties and to speak to the parties confidentially and to encourage the parties to go in different directions and to sit down and talk to the parties about what their real problems are. I said to you before that people behave irrationally or people want to breach contracts. The mediator might sit down with a party confidentially and say, please tell me what your true motives are for behaving this way. You're saying one thing in your open correspondence. Let's sit down and talk through what your true motives are and what you really want to get out of this dispute. And the other thing that a mediator can do is reach a settlement which involves the contract and the dispute on the papers, but also involves other stuff. An arbitrator can only decide the dispute in the contract. A mediator can take into account lots of other things. They can take in, I've seen mediations which start off with a breach of contract and result in one company selling an asset completely to the other side. You can see mediations which involve the whole company being dissolved. I mean, there's a whole range of possible outcomes you could get out of a mediation. Mediation does depend upon the skill of the mediator. It involves someone sitting down, listening patiently, being imaginative, being creative, trying to bring the parties together. Sometimes it works, sometimes it doesn't work. They say generally mediation has a successful rate in getting to settlement. They talk about something about 3/4 of matters that go to mediation reach a settlement. Query whether those settlements are good settlements, but very often you will get a settlement out of a mediation. It's a private process with private effector, I said here. So it's a private process like arbitration. It takes place in a private room. No one can come in and watch. But the result of it is an agreement which then stands as a separate contract. You can't take it and enforce it through the courts. You can't take it and turn it into a judgment. There's a new thing called the Singapore Convention on Mediation, which we can come back to if you like. But generally speaking, the outcome of mediation it's just another agreement and it's another private matter. The scope is defined by the relationship between the parties, so it's not defined by the contract. It's defined by the parties' relationship generally. It's party funded, as I've said, it's party organised. It's got an open group of people. You don't have to be, you can have anyone in the room that you like. You don't have to have lawyers, you don't have to have judges. I mean, it just needs to be the people in the room who are willing to talk about the dispute and willing to resolve the dispute. And you can have whatever language you like and whatever culture you like. So it's much broader than arbitration.
Ben, I wonder, maybe you don't want me interrupting. Are there certain types of disputes that are not suitable to mediation? Maybe certain, I'm just thinking if you've got a state party, a state company, ministry or whatever that is involved in the dispute, how would that work in mediation? Would that be different in any way?
You're right. In my experience, state parties are very difficult to negotiate with. So I did a dispute for Siemens about the construction of a power station in Uttar Pradesh in northern India. And that dispute went on for a very long time. The arbitration itself was pretty straightforward, but it involved various applications to court and all sorts of things. So it actually extended over 10 years or so. Now, during that time, we did try to negotiate on many occasions, and each time the person in charge on the Indian side would say, we'd love to negotiate, however, we don't want to because A, I don't have the authority to do that, and B, this is going to go on for so long that I'm going to be retired. It's no longer going to be my problem. So there is certainly a mentality amongst state employees not to take responsibility and not to, and to just, they like to have final decisions. Having said that, there are some cases where they will mediate. It's very, very difficult to give generalizations. There's something called investment treaty disputes. So investment treaties are treaties between two nation states giving individual rights to companies. So the case I'm going to talk about is a case which we brought as a private company against Hungary under a treaty which involves lots of different countries called the Energy Charter Treaty. Now, if you look at the ICSID website, which lists out all the investment treaty cases, and you see which ones are settled, there's a surprisingly high proportion that settle. But equally, state parties are driven by politics and often don't like their publicity. And often they like to keep things quiet. So it depends. I mean, generally speaking, in terms of mediation, yes, there are some disputes that are not suitable mediation. Those that normally depend on the personalities involved and normally depend on the timing involved rather than the type of contract. I don't think that there are particular types of contract that you couldn't take to mediation if you had the right people involved and if you had the right time.
I was just thinking that somebody, especially if it was a mediation involving the state, you might get a settlement, you might get an agreement, but back home, so to speak, say it's your Nigerian National Petroleum Corporation involved in this mediation. Back home in Lagos, somebody would be saying, I could have got a better deal than that.
Absolutely.
The deal has been done, but it's not a good deal.
Absolutely.
They could get involved in lobbying the government, they could say things in the media, and it could be undermined by saying something like that.
Absolutely, and this is the politics of it. And if you're talking about a state in particular, you're likely to be talking about either elected officials or people who are involved in politics and could be at risk of criticism for doing a deal. On the other hand, there may be a change in government, and the new government may want to settle and blame the old government. I mean, I gave you a real-life example again. I'm doing this case against Hungary, which is just finished. I'll tell you about it in a second. That involves the government of Viktor Orban.
Oh, yes,
Viktor Orban is up for re-election in next month.
yes.
If he loses that election, I can pretty much guarantee you that the new government will say, here's a check to our client. It was all Viktor Orban's fault. On the other hand, if Viktor Orban wins, then he'll probably say, continue to fight it. So, yeah, there's all these political dimensions to those sorts of disputes.
Okay, well, please go ahead.
Okay, so I've talked about, any more questions about mediation? Please.
In cases where arbitration is followed up by mediation, where the parties have a dispute resolution clause,
Yes.
in case of a dispute, they try to resolve it by mediation, but within a span of 45 to 30 days, it does not get resolved, and accordingly, it will be further subjected to arbitration,
Yes.
which have to be dispute resolution clause. In situations like those, if the mediation, whatever, if A item has been decided in the mediation, can the parties renege again in the arbitration?
Yes, so what you're talking about there is a hybrid or a multi-tiered system. So it's at the bottom of this screen here. You could have ARB, MED-ARB, ARB, MED-ARB. These are combinations of these different systems. So what your example was, someone goes to a mediation, then goes to an arbitration. Well, so go back to the mediation again. A mediation is negotiation, like a contract negotiation. If that fails, there's nothing to enforce. You just move on to the arbitration. On the other hand, if it succeeds, then success involves a binding settlement agreement, and you're given another contract. And that contract can be enforced. That contract could have an arbitration clause in itself, could have a litigation clause, there are other mechanisms to enforce it. So that's the general principle. You'll be able to force that settlement agreement. There are some systems, particularly in Singapore, where you could have ARB, MED, ARB, which involves starting an arbitration, pausing it, going to mediation. If you get a settlement, you take that out of the mediation, put it back into the arbitration, and have an arbitration award issued to record the mediation settlement. And then you'd have an arbitration award at the end of the day. There's also a system called the Singapore Convention on Mediation, which involves taking a settlement agreement. So forget about ARB, MED, ARB now. Just going back to the settlement agreement that you've got. You take that and you enforce it in another country under the Singapore Convention. That's a system that is new, it's untested. I have my doubts whether it will work because it involves getting a certificate to show that it was done properly under a proper mediation, and parties may want to challenge that. So there's also the difficulties with the Singapore Convention, but generally speaking, it's a new system that may allow for enforcement of mediation settlements across the world. Okay. There's a question over here. I saw a hand. Yeah. Now that's a very interesting question. So the question is, can the arbitrator also mediate the same dispute? I think that's the point. So ideally, you'd say yes. And because if you have an arbitrator and you pay them a lot of money to get up to speed with the dispute, and they sit down and read all the details, they would be perfectly positioned to help the parties mediate. And actually, in China, they think that's a good thing. And you can have, in China, arbitrators who then shift to mediate the dispute. And that is a successful system. However, other parts of the world say, no, that's not a good thing, because if you're in a mediation, that involves you having private conversations with each party and finding out all sorts of confidential information, which is fine if the mediation is successful and there's a settlement agreement. Or what if it's unsuccessful and you have to go back to the arbitration? And then you've got an arbitrator who's got all this confidential information in their head. and it's had all this private conversation with parties, how could then the arbitrator be neutral? So in places other than China, they say that's a bad idea, and if you are an arbitrator, you can only be the arbitrator of the dispute, and someone else has to be the mediator. In the UK, yeah, that includes the UK. So generally speaking, well, no, an arbitrator can only act as an arbitrator. There's no law against it. No law that says you cannot do this. And if the parties agree it, then yes. But there is a law, the Arbitration Act, which talks about the need for arbitrators to be independent. And if you have this system where they are a mediator and they've got all this confidential information, there's probably going to be grounds to challenge that independence when they go back into the arbitration. So in England, the culture is to say, no, you can't do that. Even though, as I said, there may well be some very good advantages in doing it that way. Any other questions? All right, I'm going to just mention some other dispute resolution systems. Adjudication. Adjudication is a system that is usually quite specific to certain industries, most obviously the construction industry. And it involves having a short-form arbitration, in effect. It involves a system where you can have disputes starting, parties presenting their cases, a third-party decision maker coming to a decision, but very time-bound. It has to be done within 28 days, within 1 month. And in recognition of being time-bound, you are able to challenge that decision to a court or arbitration in the future. But the advantage of doing it this way is that you get to a decision very quickly. And in particular industries, most obviously construction, getting a quick decision means money flows. If you're thinking about a big construction project, you'll have lots of different companies involved, contractors, subcontractors, etc. If one party doesn't get paid, they may refuse to do their job. And then the whole project fails. So within construction, this system is a very good way of getting the money flowing, even though there may be a bigger dispute further down the line. Adjudication allows the process still to get going. Litigation, I should have said that before, litigation, generally speaking, takes about a year or so. Depends where you are in the world. It can take much longer than that. It can be shorter than that. Litigation, of course, also may involve appeals to different levels of the court system, so you can add on another year or another year. So it can go on for many, many years overall. Arbitration, generally speaking, very roughly, takes about 1 to 2 years. On the other hand, there's no appeal from arbitration, so it's shorter than the court system in that sense. Adjudication, 1 month. Very quick and dirty, as they say. Expert determination, that's where you, instead of having a arbitrator decide something, or a judge decide something, you appoint an expert to give a decision. So it's very similar to arbitrating litigation, but you have an expert instead. Now, the advantage of doing that is that the expert applies their own expertise to the issue, and also is not bound by the same rules as an arbitrator and litigator judge. On the other hand, they do not have the same immunities that an arbitrator and a judge have. The arbitrator and judge, you cannot sue them if they get it wrong. The expert, what they do is applying their own expertise, and therefore they're at risk if they get it wrong. And as a result, they want to keep their determination as narrow as possible to a very specific question. So expert determination is useful for very technical questions, but it's very, very limited and can't be used in the same way that arbitration and litigation can. Again, expert determination, very common in the construction industry, chemical industry, and those sorts of industries. Early neutral evaluation, you don't see it very often, but it is used in some parts of the world. That just means that if the parties have a dispute, they refer it to a third-party neutral to give a non-binding decision. rather than going to an arbitrator and judge. So you appoint someone, eminent lawyer, for example, you say, we have this breach of contract, please tell us who is in the right and who is in the wrong. The evaluator will say, I think this party is in the wrong, that party is the right. But my decision is not binding. But what you can do, take that decision and then go and have a settlement discussion or go and have a mediation, whatever. If there's no settlement, the parties can still go off to arbitration or litigation or whatever, have a binding method. This is a non-binding way of doing it. And again, it can be done relatively quickly. Conciliation is much like mediation in the sense that you have a conciliator instead of a mediator helping the parties come to a decision. But this is the difference between mediation and conciliation is the conciliator is much more active in suggesting ways out to the parties, can be much more directive than a mediator can. Negotiation, very obviously, that just involves the parties getting together, trying to resolve something. And these hybrid methods involves taking all these long lists of dispute resolution methods I've referred to and combining them all together, usually in a very structured way. So you do see sometimes some quite complicated dispute resolution clauses, which involves various different steps. These are multi-tiered dispute clauses. Number one, you have a negotiation. If that fails, you go to number two, mediation. If that fails, number three, you go to arbitration, for example. Or you may carve out one particular point and go to expert determination, for example. So that's how they're normally structured, 1, 2, and 3. I've talked about ARB, Med, ARB, and I've talked about ARB, Med is where the point I was saying earlier about having an arbitrator who then becomes the mediator, which happens in some countries, but not in others.
Is there something called an escalation clause?
It's the same as a multi-tiered dispute clause, so escalated. Go upwards, shouldn't you? An escalator, or downwards. So you move through the flow of a dispute clause. I should say that those sorts of clauses can be very difficult to draft. They can also impose things on the wrong time. I've been in lots of cases where the parties have had their negotiation and they go to mediation, but because they have to under the clause, but because it's too early to go to mediation, the mediation is a complete failure and they end up in arbitration. But equally, I've had cases where there's no clause like this. They start the case, the arbitration, they set out their arguments, and then they have a mediation which is successful. Because timing is very important in dispute resolution. Please. So litigation, very obviously the courts, and national bar associations for the people who practice in those courts. There are also various international court bodies as well. In fact, there are also some international commercial courts these days as well. So there's a whole system of courts, but they're very national based. For expert determination, there aren't. So let me just talk about the arbitration, so people first can understand. Everyone else in the room can understand what we're talking about. Within arbitration, there are these days lots of arbitration institutions throughout the world who will issue arbitration rules and administer arbitrations. For example, we have the London Court of International Arbitration, the LCIA. They issue rules and they will help the parties administer the arbitration. You do not have to use one of those institutions with an arbitration. You can do it without that, but generally speaking, they're quite helpful to have. Now, expert determination, generally speaking, you don't have institutions. There are some out there. So the ICC, which is a big arbitral institution in Paris, they will also offer services to administer an expert determination, and they also offer some rules for an expert determination. But there's not many like that. Mediation, similarly, there are some institutions that will help with that. The LCA actually will help with mediation. there's an organisation called CEDA, the Centre for Effective Dispute Resolution, which will also help run mediations. There's less of a need in a mediation to have an institution, however, because mediation is more about the parties willingly coming to a mediation. You're not forcing them to be there. Unlike with arbitration, where you may well be forcing at least one of the parties to be there. Adjudication, there's a few. The Chartered Institute of Arbitrators appoints lots of adjudicators. The Royal Institute of Chartered Surveyors in the UK appoints lots of adjudicators. Some other institutions in different countries appoint adjudicators. And the other ones, they don't really apply. Only for mutual evaluation, you normally go out and find someone who you think is appropriate. You don't really not have institutions for those types of dispute resolution.
And I was just thinking that maybe it's relevant to point out that with, say, expert determination, the person who's the expert doesn't have to be a lawyer.
That's right. They have to be an expert.
Yeah, they have to be an expert.
So,
Not necessarily a lawyer. Could be a construction, an engineer, maybe?
yeah. So I did a dispute in Myanmar about 10 years ago. The dispute was all about the amount of gas in an offshore gas field. I was acting for a Korean party who were one of the joint venture parties in this field, and on the other side we had the state gas company. And we had expert determination, and what the expert had to do was simply to decide how much gas there was there in that reservoir, which is more difficult than it sounds because it's under the sea, and you need to work out, actually you need to work out not only how much is there, but how much you can feasibly get out of that well. And so that person was an expert, wasn't a lawyer, he was an expert.
Okay. Would that outcome, or would his or her recommendation be binding, or would that depend on the parties? Could they say it's not going to be binding, or it is going to be binding?
So you can have an expert determination which is not binding, that's closer to the early neutral evaluation, but in that particular example I gave, that came out of a clause in the contract. So the decision of the expert was binding. It was then enforceable via the contract, which had an arbitration clause in it. So the effect of the expert's decision was that it became a clause in the contract, which if it was breached, if one party didn't comply with it, you could then say, we're now entitled to damages, and damages via the arbitration route. Yes?
Quite understand the adjudication process. Apart from you saying it's shorter than litigation, then you mentioned something about construction as well, like maybe while the construction is still going on, just when.
Yes. So construction is just an example. It's an example where it's commonly used. Adjudication is used where there's a need to get to a decision quickly. So why construction is a good example is that we're talking about, for example, building a power plant. And a power plant is a very, very complicated structure, and you need to build foundations before you can build the top of it, for example. And it has to be very sequenced. And the people building the top bit cannot do that until the people at the bottom have done their stuff. And if the people at the bottom don't do what they're meant to be doing because they're not being paid, the people at the top can't do what they're meant to be doing. So there's also these implications for money not flowing and decisions not being made. So that's why adjudication is useful to get to a decision quickly. Now, as I said, construction is just an example. It's a very good example. It's where it's most commonly used. But it can also be used in any other contract you like, any other system you like. But there are advantages and disadvantages to it. I did an adjudication 2 years ago, which took a month. Yes, it was a month, done within a month. It was a residential property, actually, on that one. And a chartered surveyor was the decider, was the adjudicator. We put in submissions. The other party put in submissions. The adjudicator came out with a decision, which frankly we were very unhappy with. We thought the adjudicator got it completely wrong. And actually, if you read through the decision, you'll see it was very badly written. But it was a decision, and money did flow, and as a result, but that decision could still have been challenged because it was such a bad decision. So we could have gone further. Now, in that particular case, the client just said, oh, let's just do it. Just pay the money and move on. And so that's the advantage of adjudication. Sometimes parties will just say, we want a decision, even if it's a bad decision, we'll just want a decision.
So someone can say that your adjudication is basically about just continuing the process, getting the money instant instead of waiting for.
Exactly.
I know it's kind of different from what injunctions do in normal litigation process. Like injunctions is more of like trying to like
So injunctions are a particular part of the process within litigation or arbitration. Injunctions are called, you can refer to them as interim measures. So they happen during the process. And they usually involve ordering one of the parties to stop doing something, or to start doing it sometimes, or to preserve evidence, preserve assets, until you get to the final decision. I did a case a while ago, actually, I might talk about it in another slide, which involved freezing an amount of money which was sitting in a Singapore bank account until the main arbitration was finished. And I gave an order that that money be frozen till the end of the process. And that's different from adjudication, because adjudication involves getting to a decision on the main issues in the case. And an injunction, you don't have to decide the main issues in the case. You just have to decide on whether to freeze the money, if it's a freezing injunction, temporarily until the judge at the end of the case, or the arbiter at the end of the case, makes a decision on the main issues. But adjudication, they have to decide the main issues. And they're not, it's not interim or anything like that. It's more like a first instance court, where you come to a decision and then an appeal judge might review your decision.
I'm wondering, I don't know if you picked up on that point there about procedural or provisional measures. That can be quite important if your process starts and you're a bit worried that one of the parties is going to be doing something that maybe involves hiding money away or spending money, or money that disappears. So you may want to ask the arbitrator to take some action to stop this. So what you're trying to get out of the dispute might be disappearing because of the actions by the other party. That's possible.
Yeah.
I mean, these things happen, and you have to be quick. So I guess it's the sort of thing you would have done when you were in practice as a law firm. You have to be very fast.
Yeah.
Or you find that the objective of the whole exercise is impossible to achieve because the other party has taken all the money to Panama or whatever it is, or not that there's anything wrong with Panama, of course, but somewhere where it just couldn't be achieved.
I've got an example coming up of an injunction application on my slide.
Good. I think maybe some of you might want a break at this point. Yes? Nodding? Definitely. Okay, right. Okay, some of you might want to just a little, whatever it is, I think it's called comfort break. Is that what it's called? Anyway, lots of euphemisms. So can we have just maybe 10 minutes, something like that? Keep it nice and short. And then please come back. What? Oh, and you want the authorization code, didn't you? Don't you? Yes, I think that's... I will give it to you when you come back. An authorization code. Did they have that when you were... no.
about the charting technology. That's the most best advice I can give. Where are you going to be at your people? Okay, well, if you're staying in the UK, I mean London, I'd like to take it on here. That's probably simple. It's,
And also, I applied some law firm, boutique law firms for voluntary internship. I'm waiting for response from them as well.
so that's londonarbitrators.org.
Okay.
Now that's the London branch of the CIR, and they do events every month. And to join the CIR, one of your students is free, so you can join up now when it's listed. Go along to these events and talk to people about arbitration, talk to people about opportunities for the arbitration.
Okay, networking then.
Networking, yeah. So that's the best advice I can give you. Once you've finished this course, when it's you can become a full member of the CIR, but then you can also do the various courses on offer, and then learn about arbitration, get qualifications. That can help you along the journey as well.
And also, is it beneficial for me to do master in this program?
It's very difficult to say, to be honest. I did the equivalent of a master is a Phillips Arch, which is a diploma in arbitration, and I thought it was useful. But equally, I know lots and lots of people who are very successful careers in arbitration who've never done masters. So it depends on your circumstance. It depends on how much you want to spend as well. So it's not a. I can't really answer this question.
Oh, good.
There are some very good courses in Queen Mary, a very good arbitration course, a master's course in arbitration. So while you're here, you should go investigate it. Go and speak to Nora Gallagher or Lucas Costello. All these people do, or Peter, who also know about it as well, and talking about what that course involves. Because yes, it will give you a benefit. You'll learn more about arbitration, you'll speak to more about arbitrated people, give you a qualification to go out in the world with. But on the other hand, it's another year of your life, it costs a lot of money, and there's all these other factors. So you've got to weigh it all up.
Okay, thank you so much.
I mean, I would say if you could get a job in a firm that's very good at arbitration, that's even better than getting a master's. You learn so much more by actually doing arbitration. But it's very hard to get a job, so that's the problem.
Yeah, I know. It's competition. There's a lot of competition. Thank you so much.
So if you go about getting an injunction, it's not just high courts in the UK, but it's like...
But it depends where you are in the world. So let's talk about England. If the dispute resolution method specified in your contract says English litigation, then you can go to the English courts and get an injunction to do whatever you want done. On the other hand, if the dispute resolution clause in your contract says that the disputes have to go to arbitration, then first you have to check where the arbitration is. If the arbitration is in France, for example, then the English courts have the power to issue injunctions, but only very specifically over assets that are here. So, for example, if money is in your bank account here, they could freeze that in support of the arbitration in France. But other kinds of injunctions they can't issue. If the seat arbitration is in England, then the courts can still issue injunctions to freeze assets, but and do other things. But then they are limited by the Arbitration Act that says they can only act where the tribunals cannot act. And some tribunals can issue injunctions themselves. So then you have to see where is the dividing line between the arbitrators and the courts. So it's a complicated question.
Okay.
I'll answer your question. The basic answer is that the courts have powers to support arbitration, and that includes issuing injunctions.
Okay. That leads on to like the next question. If injunctions are time is of the essence to then actually do it fundamentally, for example, like freezing order, how does that solve?
Well, the other crucial thing, difference between arbitrator litigation is that an arbitrator cannot hear parties on an ex parte basis. So when they have a hearing, they always have to have both parties present. Courts do not have to do that. Courts can hear what's called an ex parte injunction, which is only one party in the room. And that's important where you don't want to tip off the other side. So particularly about money can move around things. You don't want to tip off the other side that you're about to apply for an injunction. So in those circumstances, you wouldn't go to an arbitrator. You'd have to tip them off. You have to tell them, you know, to go in front of the arbitrator. So then you go to the court to get an ex parte injunction, and then have it enforced after that. The way that the courts work is that the courts can issue an ex parte injunction, but then you have to come back with inter partes hearing a week or so later. So it's only issued on a very temporary basis. And then you have to come back and have both parties present their case. Whereas arbitrators cannot do that. They cannot have an ex parte litigation.
So, because I'm trying to understand, because I did this Q1 January, so I went through all of that.
Yeah.
I'm trying to understand in arbitration still sort of how exactly this injunction operates. As you mentioned, if you want to get one party, you have to go to court. But if the assets, my concern is that the time frame is so
depends
short.
depends what the asset is. So if you're talking about a movable asset that is very difficult to move, ship, massive tanker, which I know they can set sail, but you have to, there's a whole bunch of process to make sure it's set sail. You may have enough time to go to an arbitrator and have an argument. So you could appoint an arbitrator in a matter of days, you can have a hearing in a matter of days. So I want to talk about this in a second, with emergency arbitration. You can obtain an injunction within 2 to 3 days. But that's a situation where there's no risk in the other party moving it quickly.
Okay.
On the other hand, if you talk about an asset which can be moved very, very quickly, cash in a bank, then there's no point going to the arbitrator. You should go to the courts.
Okay.
So it depends on the asset, depends on where the asset is as well. Another aspect is some parts of the world you cannot obtain an injunction at all. So Indonesia, I did mention earlier, it is right, you cannot obtain an injunction out of the Indonesian courts. So you've got no choice but to go to arbitration about that. And just run the risk, you won't be able to get it in time. There are also courts in the world which are corrupt, which have difficulties. I mean, for example, try and go to Iran now, apply for it. When you use your British passport or you've got, say, I want to come to Iran, they'll say, no, go straight to be thrown in jail. I mean, so there's practical difficulties on this stuff. And then you may have to look another way of doing it. So,
Okay. So one last question. So if you do enter, let's say, arbitration sea-based, as in Indonesia, that's the onus is on you. You're the one running the bad part, you would say.
yes.
Okay.
Just because.
Yeah. Okay. Thank you.
Why you wouldn't have an arbitration in the first
Okay. Okay. Thank you.
And yeah, so you need to think ahead when you're signing up these calls. You think ahead what you might need to do in the future.
Yeah, I'm sure they are.
Hi.
Hi. Question. So it's regarding, of course, as you mentioned, we know that it is used in legal convention to enforce foreign words.
Yes.
However, what happens, because it's foreign words, what happens with national words? That means we need to follow the national rules, and what if they are not pro-arbitration?
That's right. Do have to follow those. So the New York Convention has a lot of advantages, but it has some disadvantages as well. The advantages are you can enforce it, generally speaking, all over the world. There are also very limited grounds in which you can resist enforcement. On the other hand, there's you're mentioning it's a big process. There's lots of you can end up having litigation in a whole different country or something. Whereas if you do force it locally, there may be much more opportunity just to apply locally for binding court judgments or ex parte injunctions. That guy, you might be able to appeal it. There's all sorts of other things you can do to it's a very general answer, I know, because it really depends on which country you're talking about. In Singapore, for example, we have the International Arbitration Act, which applies to international arbitration, but the Arbitration Act, which applies to domestic arbitration. And if you have a Singapore award, of course, in Singapore actually could follow the International Arbitration Act, but generally it will follow the Arbitration Act. The Arbitration Act has a wider range of mechanisms to enforce than under the International Arbitration Act. Yes, I can't remember.
Okay.
But I mean, there's a lot of overlap between them. And in fact, in some countries, well, including in England, there's no difference, real difference between domestic and international. But in others, there are. And so it's a very
So in those
general
ones
question.
where they do not have the visa place, what happened?
So if you know India, India has had a lot of problems with enforcing foreign awards. And the reason why, it's very obvious why they have problems enforcing arbitration awards. It's because they try to apply into the domestic principles within domestic relations and international awards. And very often, what the judges are trying to do is help out the foreign investors. So that's how they get into problems over it all. So India is a prime example where they should have an arbitration, a local arbitration law, and a foreign arbitration. And they've tried to mix them up. So, yeah, it all depends on where you are in the world.
Right. Thank you.
How you doing? You all right?
Yeah, good. Yeah, I might be going on a bit here. I'm
No,
sorry.
no. It's fine. They're comfortable. I can tell that they're very relaxed. So I think with some of them, there's a risk that it's rather new, difficult. So I think a slow pace is good. You know, not to leave it. I mean, some of the applicable law was tricky at the beginning, but maybe later it'll start to sink in.
Yeah.
Because it's not really an arbitration course. It's more wider than that, much wider.
Yeah.
But it's important that we have cover all these issues today. Really, it's important. So I just interrupted a little bit because I just thought it might help clarify some points. There's so many points you could make. You know, this is really you have a whole course on this easily. So, do you keep in touch with the arbitration people at all? Do you know any of my colleagues that are in the? You do, yeah. Because we all sit in the same corridor, really, or floor. So it's energy and arbitration together. Really.
I know Lucas pretty well. I was on the board of in London in session with him.
Right.
I know Krina very well.
Yes.
She's does stuff at the Chartered Institute as well.
Right.
I know Nora a bit. So yeah, I knew Stavros quite well.
Oh yes, of course. No, but in Singapore. Yeah, sure. Yeah, we have Maxi as well. Maxi's,
I saw Maxi in Singapore.
Yeah,
I saw Paris.
We share an office space. But I joked with her. I said, I never see you, and it's fine because I've got the space. But she thinks this is funny.
David Gilmore Thomas, who's got.
Oh yes, I never see him here, but I don't know what he does now.
Well, he, I don't know, he's still got some sort of title. But he is in the same arbitrator chamber as Sam Jordan. So I'll see him tomorrow.
Oh, all right.
We'll meet him tomorrow.
Sure. Yes, I knew his mum very well years ago, Elizabeth Thomas. Very good administrator, very good, formidable. Yes, David, I've met him a few times too. I don't know him very well, but I mean, he's a very pleasant individual, very engaging.
His father was a medical professor, I think, in Edinburgh.
Yeah, I remember that because his mum used to travel with him to all sorts of places in the Caribbean and some nice locations at a time when people travelled rather less than now. And so he would get invited to medical conferences in these nice places, I don't know, Miami and places that seemed very exotic at the time. And she would go along as well and had a nice time. So I do remember that. We were all quite envious of her when she went off on these trips. And that was his dad. I don't think his dad's alive, but his mum certainly passed away a few years ago now. So, good. Okay, we can maybe just get back. Oh, you've said something about the book. Maybe I'll say something as well. That might just underline. There's no harm in kind of giving the message over a few times. All right, everybody. Let's resume. Some people will be coming back a little bit more slowly, but I know that you're the conscientious, attentive ones, and you're here already. So. We're not going to keep you waiting, right? So everybody is just about to get started. And maybe before we do get started proper, I could just mention that there is this copy in the library of the Arbitration Act commentary on it. This Arbitration Act 1996 has been very, very influential. And with some of these pieces of legislation or model contracts, it's important to keep in mind, even if the year sounds quite old, something that was adopted a long time ago, often they're updated or they're modified, or you find that there are references to them in ongoing disputes. With some of the normal contracts, you find there are references to them in contracts that were concluded some time ago. So sometimes things can be alive and well, even though the date on them can be some time ago. But this particular book is not old at all. It's quite recent. I think only came out this year.
December.
Yeah. In December.
Yeah.
December last year. So only a few months ago. So it's reasonably priced, the paperback, is it?
I don't know how much.
Most authors don't know things like this. I'm actually very, very traditionally Scottish. So I always know the price of things, and I always investigate, and I talk to publishers about money. But you see, Ben is a gentleman, and he doesn't bother about things like that. So this is probably a student edition. So I think you'll find that the hardback will probably be incredibly expensive, but the paperback not. Do you need to take a picture of it? Arbitration Act, Wiley, W-I-L-E-Y. Wiley Blackwell is the publisher. Arbitration Act commentary. So you can look at one particular provision, and then you find lots of explanation of it. It's really quite reasonable. It's not the sort of book you're going to read, I think, from page 1 all the way through to the end, I'm afraid.
If you want to stay awake, no.
It's not that kind of book, but it's a very practical book. Okay,
So,
Ben, over to you.
I donated the copy to Queen Mary, by the way.
Yeah. Thank you.
The code.
What?
They want the code.
Did you give us the code?
Oh, you haven't got somebody not got the code?
Yeah.
Oh, let's just clarify that. Some of you, I went around giving the code to many of you, but some of you may not have the code. DK MR XG. Everybody okay? Good. Let's continue then. This is just to say that they were here. So it's all checked. I'm afraid. A change since you were.
Okay, so earlier I was talking about litigation, arbitration, expert determination, mediation. Now, there's a term in dispute resolution which is ADR. ADR, you'll hear talked about a lot. And I just want to flag to you that ADR has various different meanings. ADR could be alternative dispute resolution. And it could, and this is, it's often referred to as alternative to the courts. So arbitration is ADR because it is an alternative to the courts. However, you could also have ADR, which is alternative to arbitration, rather confusingly. So arbitration and litigation are binding methods of dispute resolution, whereas mediation is non-binding. Therefore, that is an alternative to arbitration and litigation. ADR is sometimes referred to as amicable dispute resolution as well. So early mutual evaluation, mediation, conciliation, these are all types of amicable dispute resolution. ADR is also, they talk about appropriate dispute resolution. So a system which is designed for the particular dispute. Arbitration, most obviously, could be designed for the particular dispute. So ADR is just a term which can change meaning depending on what context you're in. All right, so I have talked about these various processes. I'm going to give some examples now of cases that I've done. And I'll talk through, these are all arbitrations, because arbitration is what I do. These are all cases which I'll talk through the timetable, but as I talk through them, I'll talk about some of the issues involved, the case involved, etc., etc. Now, I'm going to start off, frankly, with the most difficult one, which is the case against Hungary. And I just started with it because it's fresh in my mind. I finished it in February, so in fact, it's not quite finished yet, as you'll see, but the main part of it finished in February. So I spent lots of January and February learning up about Hungarian law. So as I said earlier, this was an investment treaty case. We were acting for a company that invested in a power station in Hungary. The investment was with a contract. The contract was signed with a Hungarian energy company, the state-owned energy company, and there was a arbitration arising out of that project. Now, my client won that arbitration. That arbitration was way back in 2012, and then the client, tried to enforce that arbitration award against the state energy company, and we tried to enforce it by going through the proper processes in Hungary. And the arbitration award was upheld by the Hungarian courts. The Hungarian courts, said, yes, this is a valid arbitration award. And they converted it into a Hungarian court judgment. And the Hungarian courts then said, yes, you can enforce against this arbitration award against the Hungarian energy company. And our client applied to take some money out of the energy company's bank account to satisfy this award. I mean, they literally written out this application, they literally filed it at the court. At that point, the energy company said, well, when our CEO signed this contract, he committed a criminal offence. And therefore, they ran after the police and said, a criminal offence has been committed, and please seize this money. Now, obviously, if a criminal offence is committed, then this, by the way, I see people taking photos. This is all on the public record. This is on a website. So what I'm telling you isn't on the public record. This is it will be in the future, but I gave it far. But so don't recall what I'm saying. But yeah, you can look at that. They said, so this man has committed a criminal offence. Now, if there's a criminal offence, then criminal powers step in, obviously. The criminal police step in, obviously. That's no one would dispute that. However, this particular type of criminal offence in Hungary, breach of fiduciary duty, necessarily involves the payment out of money. So this man could only have committed a criminal offence by the money reaching my client. But the money never reached my client because the police had it, because the energy company, instead of giving it to my client, they gave it to the police. So you think, well, how could this criminal offence have happened if the money never came to the other party? So how can you seize the money when no criminal offence has been committed? So it all got very strange. So our client went back to the Hungarian courts and said, this is very strange. Why is the energy company effectively freezing its own money? And there's no offence to be committed. And the Hungarian courts said, yes, this is very strange. And therefore, you, my client, can enforce it against another bank account. Because they'd only froze the money in one bank account. This energy company is very, very big. You can have the money over here. At which point, the Hungarian parliament stepped in and they issued a special law. The law said that if money has been frozen, you cannot enforce an arbitration award. And although they didn't name my client, they said if it has been frozen in this specific way, that this money has already been frozen. They didn't talk about the other ways you can freeze money. They didn't talk about the other ways you can enforce arbitration awards. They just talked about this specific thing. They said if this happens, it has happened, you can no longer force an arbitration award. So at that point, our arbitration award could not be enforced, and the criminal process went all the way up to the Supreme Court in Hungary. The Supreme Court said, yes, this man has committed a criminal offence. And in fact, he committed this criminal offence when the contract was first signed way back in 2009, which then was very strange because, as I said before, this criminal offence only happens if there's a loss, if there's money paid out. And by the fact that it was signed in the criminal offence happened 2009, that meant that every time someone ordered the payment out of this money, they were accessories to a criminal offence. So that meant by implication the arbitrators were accessories to that crime. It meant by implication that the lawyers involved in that arbitration were accessories to the crime. It meant that the Hungarian courts themselves were accessories to the crime because they had helped this money be paid out. So it all became very, very strange. And then what was even strange after that, after this criminal case happened, the energy company went and sued that former CEO to the civil courts. And the civil courts said, yes, you have suffered a loss. You have suffered a loss because the criminal courts have confiscated the money. Because the criminal courts, I should have added, the money had been frozen. The criminal courts said, we will confiscate this money, give it to the Hungarian government. And the civil court said, yes, you've suffered a loss because the criminal courts have confiscated the money. But the criminal courts have confiscated the money because you suffered a loss. But you've only suffered a loss because they confiscated the money. So actually the people who were responsible were the criminal courts, so this all gets very, very confusing. So as a result of all this strange behaviour, oh, and by the way, the other thing was the criminal courts took the money, gave it to the Hungarian government. The energy company, which is owned by the Hungarian government, also got a judgment against the former CEO, took the money. So they took the money twice. It was very strange. So anyway, there is a treaty called the Energy Charter Treaty, which covers power stations and other things. Hungary is a party to this. Our client was based in Cyprus. Cyprus is also a party to it. These treaties work on the basis that if an investor has invested in a company in a particular country, and the country does something which damages that investment, you can sue the country. So in this particular instance, what we said was, yes, the energy company had originally breached a contract, but you, Hungary, have damaged our investment because you've done all these strange things. You have stopped the enforcement of the arbitration award. You have issued judgments which just don't make sense whatsoever. And you've kept all this money. Please, we have our money. So that was the point of the case. That was the whole point of the case. And we have now completed that case, and an award will be available on this case, assuming Hungary doesn't settle. And it might if the changing government is Hungary. And hopefully, fingers crossed, the arbitrators may come out, may say, yes, Hungary, you must pay damages. I may be wrong. Strange things happen, and I have lost cases where I thought I should win. And actually, the award, when you read it, may say, what Ben told you was complete rubbish, and Hungary were perfectly entitled to do all these strange things. But I'm hoping, touch wood, that they will agree with me. So the case, just go through the process. We started this case in 2024. We filed a request for arbitration on the 29th of February, very memorable, it was a leap year. The tribunal was constituted on the 8th of July. This particular type of arbitration is a bit slow in appointing arbitrators. Normally it would happen quicker than this, but this was 8th of July. We had a hearing, which is an online hearing. I did it from my bedroom. I was dressed properly, but I was actually in my bedroom when I did this, in front of my laptop. And there we made submissions about the timetable for the arbitration. And after that procedural hearing on the 7th of September, or whenever it was, they issued a procedural order which set out the timetable. We filed what was called a memorial, which just means a pleading. It's a big pleading which contains audio arguments. It also contained expert reports, other evidence we relied on, etc., etc., the whole package of things. At which point, the end of November, Hungary applied to bifurcate the case. Now, bifurcation is a special process in litigation, arbitration, and other things, which involves separating out certain issues to be heard first. And the advantage of doing that is there may be certain issues that can be dealt with quite quickly, which will bring the whole case to an end, which means you don't have to go forward and look at the other issues. And classically, in these cases, the issue that gets bifurcated is the jurisdiction question. So the question is, does this tribunal have jurisdiction to hear this dispute? And that can be for a whole range of reasons, because the dispute does not fall within the terms of the treaty, because the party is not a signatory to the treaty. I mean, there's a whole bunch of reasons why they could not have jurisdiction. And if the tribunal decides it does not have jurisdiction, then it doesn't have to go on and consider the other issues about whether the treaty has been breached. This case, they applied for bifurcation of the jurisdiction issues. We filed a response to that in December 24. There was a decision on bifurcation in December. The tribunal said, no, we're not going to bifurcate, we're going to hear it all together. The tribunal realized there was all these strange things going on, and they had to hear it all together. At which point, the other side filed a counter memorial, which is another package setting out all their arguments, their evidence, etc. In March 2025. There was a document production process in April to June 2025, which involved each side handing over documents that were requested, that were relevant to the case. And we then moved on to another pleading, another memorial in August. It was a very big one, I remember that. I wrote most of it. It was 361 pages long. And I wrote it sitting on a sofa in my front room. So, I was fully dressed again. And then there was a rejoinder in November of 25. There was another rejoinder, another pleading just on jurisdiction issues in December 2025. We then had another online video conference with the tribunal just to discuss how the hearing was going to run, the process of the hearing. That was in January 2026. Then we had a hearing in London which lasted for a week. It took place at the IDRC, which is over by St. Paul's. And that was the end of the substance of the case. We've got to file cost submissions by the end of April, and then we'll get an award later this year. So, brand new, hot off the press.
Can I just say, I hope you're picking up on this, that there's an extensive involvement of the parties in the process. It's a very different process from a legal and judicial process, which is just organised in a different way. This whole arbitral process brings in the parties, and they're constantly feeding into the process and playing, in a sense, they own it. They are the owners, and that must be very attractive to commercial parties in a dispute. where they feel, hey, you know, we're partly leading this process. We don't know what the outcome's going to be, but we're not excluded from it, and we're not having to try and work out, is the judge going to be someone who is likely to decide in this way or that way, and we've no idea what's going to go on here. It's a very different type of process, much more consensual,
Yeah.
really, and very, very good for business people.
Yeah, when I start an arbitration, I don't know what's going to happen in it. Whereas if I start a litigation, I can go online, look at the civil procedure rules, and I know exactly how it will play out because it's all set out there. But the other hand, it is very strictly laid out.
Yeah.
Whereas this, you can adapt it to fit the dispute.
Maybe the award, I don't know if you're planning to say something like that, Ben, but I was wondering, people may want to know about what goes in the award, because I think one of the oddities about the award is that a lot of it you don't really have to read. You know,
Just go to the back page.
Maybe you wouldn't say that. But.
So when I talked earlier about the New York Convention and the methods of enforcing arbitration awards, a big part of the process of enforcement involves checking whether the arbitration itself had been fair and that all the arguments had been heard and considered by the arbitrators. As a result of that, as a result of being aware that the process could be tested, arbitrators will write out in their award what they did. And so that when a judge who may have to review it later down the line can understand what has happened. And it could be a judge in this country, it could be a judge in Nepal or anywhere in the world because of the New York Convention. So you don't know where it's going to be read. So you have to be very clear in the award about what has happened. So typically arbitration awards will have the first 20, 30 pages will be just about the process. And then after that, typically you will have another 30, 40 pages summarizing the parties' arguments. Because you want to be showing to the judge who reviews this that you have taken everything into account when you reach a decision. And then you may have another whole 20, 30 pages where you analyze it and you give your decision. And then there's the very last page, you'll say exactly what the parties have to do. So that typically is how an arbitration award is constructed. And they could end up being very long documents as a result because you have to put lots of stuff into it.
I guess in this case you were looking at the tribunal. My guess was that Sands would be the respondent's appointee, and Blanche was the claimant.
That's right.
Is that right?
I mean, so when you're appointing a tribunal, typically, and in a situation where you've got one claimant and one respondent, typically each party has a right to appoint one arbitrator, and then the two party appointed arbitrators choose on the third, the president. That's a generalization. There are lots of variations on that, but that's very often what happens. So you're right, in this particular case, we were the claimant. When we filed our request for arbitration back in February 24, we nominated Juliette Blanche, who's an English arbitrator, to be one of the arbitrators. The other side, Hungary, when they responded to our request for arbitration, they nominated Philippe Sands, who is he's actually English as well, although he has dual nationality. He's Mauritius national as well as English. And the two of them appointed Gabriel Copencola, who is a Swiss arbitrator. So we did end up with two English people and one Swiss, although it didn't have to be English people. We could have been.
It had to be what?
It didn't have to be English people. We could have had any nationality. There was no English law involved in this. The English language,
Yes.
but no English law. And it did take place in London, but it could have taken place anywhere. It only took place in London because two of them were based in London. Gabriel Copencola wanted to have the hearing in Paris, but the other two said, no, we live in London, we want to do it here.
Right, right.
Right. And on our side, it was just us appearing. The firm I've been at is called Fox Williams. If any of you are familiar with English litigation, you often have barristers involved as well. And that's required in English litigation. In arbitration, you don't have to have barristers. You can have a law firm doing it. The other side, they did have a barrister from London, they had a law firm from Washington, and a law firm from Budapest involved. So a whole mixture of lawyers on the other side. That's a typical, and that process is very typical in major arbitration. The substance of it is different. The substance of these investment treaty cases is different from contract arbitration, but the process is very similar. Any questions about this before I move on? Everyone's really tired now. It's late in the evening. This is a case where I was sitting as arbitrator. It was under the SIAC rules, Singapore International Arbitration Centre. It was a case that was seated in Singapore as well, and the hearing actually took place in Singapore. It's a while ago, shows how old I am. It was back in 2015. The claimant was an Indian company. The respondent was a US company. The arbitrators were Australian former judge, a Singaporean professor, and an English law firm partner. That was me. By the way, I've not given you the names here because this is anonymous, this is confidential, but I can give you the general outline to it. Whereas what I've told you about before, that's all on the public record. The claim was about a solar power project in India. It was a construction claim. And the notice of arbitration was filed by the Indian company in May 2015. There was a second notice of arbitration. It was a different claim. But they were eventually consolidated together. That second notice of arbitration was in May 2015. It's about the same project. The tribunal was appointed in October 2015. The reason why it took such a long time to appoint the arbitrators was that in that period, they were arguing over whether the cases should be consolidated or not. We had a preliminary meeting about the process of the case in November 2015, and a timetable was issued. We had preliminary issues in February, the hearing of March 2016. There was an application for interim measures, an application for an injunction to the arbitrators. There was also an application over the jurisdiction of the arbitrators in this case. The preliminary hearing took place in April 2016 in Singapore. It was in Maxwell Chambers in Singapore, which is the hearing centre in the centre of Singapore. We gave a decision about those preliminary issues in May 2016. Pleadings were filed in statement of claim and defence in June, July 2016. I don't know why I put Singapore in there. Singapore has nothing to do with it. I think I'm meant to be with the hearing. We had production documents processed in July 2016, a further round of pleadings in August 2016. And by the way, witness statements were filed with the statements of reply and with the statements of claim as well with the pleadings. There was a hearing of a week in September 2016, cost submissions October, and we issued the award in 2016. I still have the award. I know this is correct because I copied it out of the award last week. But this is a very typical commercial arbitration involving parties from different sides of the world, taking place in a neutral venue in Singapore, this applied English law actually. I should have put that up there as well. Applying a different law. So it wasn't Indian law, it wasn't US law.
When you're asking people to produce documents, they don't always produce the documents, do they?
No.
Right. So you can. How do you manage that? I mean, you draw up a list of documents that there'll be a reference schedule. Or,
yeah. So let's go back to litigation. So litigation, typically, you are required to produce all relevant documents in your possession. There's some limitations on that, but generally speaking, if you've got documents that help your case, and also if you have documents that harm your case, you have to hand it over. That's English litigation I'm talking about. Arbitration is different in that parties will voluntarily hand over documents that support their case, but they keep back documents that harm their case. And then we get into a bit of a cat and mouse game because the other side has to ask for documents from the other party. but very often you don't know what the party's got. So you have to sort of guess. And you're quite right that the other side may hand over documents, may not hand over all the documents, may hold stuff back. You have to try and guess what they've held back. And if they do that, then you might be able to make submissions to the tribunal to say, well, you have to draw adverse inferences from their failure to produce documents. I'll give you an example. In that case involving Hungary, we asked for all documents relating to this new law. They issued a law. And therefore, typically, with a new law, you'd have a draft of the new law. You'd have papers about position papers, investigations about why you need this new law. They didn't hand over that. They handed over documents about committee meetings in the Parliament, but nothing about where this law had come from in the first place. And we said, well, you now have to draw adverse inferences from this, that they haven't handed over. They must have these documents. These documents must exist because it's a law. You must draw adverse inferences from this. Or else, if it is true that there are no good documents, then you must also draw the conclusion from that. This was a crazy law. No government issues a law just like that without thinking about it first. So either way, we were saying to the tribunal, you have to draw a conclusion from this.
Is it not the case that if you're in the United States, that American law is much more rigorous, or at least encourages disclosure of documents?
Well, that's in litigation, but that's also the true in English litigation.
Okay.
And if you don't, in English litigation, when you produce the documents, you have to sign a statement of truth saying, I have produced all relevant documents.
All right.
And if then discovered you haven't done that, you have lied to the court, and that's a criminal offence.
Okay.
So that's the penalty for.
But in arbitration, that doesn't apply.
That doesn't apply.
Did you get that point? That point about documents, so that's an important practical thing. The documents that are likely to incriminate you, you can find ways of holding them back. I think that wasn't quite how you put it, but...
Well, I don't encourage you to hold back documents as well. I don't encourage you to lie. There was a way around it. It was hardly ever used, that the Perjury Act in England, 1906 Perjury Act, applies to any oath given in proceedings, which is broad enough to cover arbitration proceedings. So you could have a statement of truth in arbitration. I've never seen it done. You can also have a witness statement in arbitration where you sign it as a given oath. Again, I've never seen it done, but there is a way of doing it. But in practice, it's not. Yeah, that's it. Yeah, hi.
Instance, can you file interrogatories? Is there like a discovery procedure?
So in arbitration, do you mean, or?
In arbitration?
In theory, yes. So the process in arbitration is for the arbitrators themselves to decide. So if they think it is appropriate, in any case, to have interrogatories or parties to provide further better particulars or to hand over particular documents if very such the case, they can order it. In practice, it doesn't happen very often for a whole range of reasons, partly to do with the arbitrators want to keep the case on track. Applications like interrogatory applications just end up derailing things sometimes. Also, sometimes they try to have an approach which is a common standard. And sometimes there are processes familiar to one party which are totally unfamiliar to another party. And it might be unfair if you've got one party fighting under their own way of doing things. The other party don't know what's going on. These are reasons why they might not do it. But they can do it, absolutely, they can do it. Does that answer your question? Yeah.
Different states where there are laws around the limitations around arbitration. What if in the proceeding where there's no limitation, proviso or a statute acting per se, where how does we determine that in how much time the documents have to be procured or to be delivered, considering there's no limitation?
So that's a procedural point about the timing of document production. And in court systems, there will typically be a time set out, which a judge can vary, of course, but it's typically set out. Here, in arbitration, it may not be set out anywhere, but the arbitrators will specify it in a procedural order. So it may not be set out in arbitration rules, but there will be a rule, an order for that specific arbitration where they've set it out. So it'll be up for the arbitrators to determine what the appropriate timing should be.
That would be subjected to all disputes.
Well, yeah, it depends on which dispute you're talking about. Yeah. Which is, I mean, again, it's the advantages and disadvantages of arbitration. On the one hand, litigation, you know exactly what's going to happen, subject to a few variations. But on the other hand, it's very rigid. With arbitration, when you go into it, you don't know what will happen, but it's much more adaptable, depending on the particular dispute.
And sorry, just a small point. If the parties were supposed
Well,
to,
just, yeah, go on.
if the parties are supposed to procure or deliver the documents in a week time, let's say, and they don't, how often is the chances that any preliminary award or any cost are imposing as a part of that reduction of documents? Because that's a very handy tactic to delay the proceedings.
Well, again, so you're talking about a situation where they are going to hand over the documents, but they're just late with it. Again, when you're in litigation, as you've correctly pointed out, there may be all sorts of cost implications for that. In arbitration, there could also be cost implications. The arbitrators have powers to impose cost penalties for failure to comply. However, in practice, they don't really do that, I'm afraid to say. This is one of the criticisms of arbitration, that arbitrators should be more, no, they should be more stricter about these things and impose stricter penalties. The issue there's a whole bunch of issues why they don't do that. If you go back to the court system again, when they oppose costs orders, there's a whole mechanism around that to determine how much costs, how it's going to be enforced, what are the implications if they don't pay the costs. Arbitrators don't have that. They have themselves. And so if you're going to go down the cost route, you've got to think, well, how much has actually been spent, but wasted as a result of this? When are you going to charge it? How is that going to be enforced? Typically what arbitrators will do is to say, yes, you should pay advert costs, but we're not going to work it out until the end. And then when you get to the end, well, it's all to be overtaken by the main case. So arbitrators don't typically, they're not typically as forceful as judges, I might say. Okay, please.
And apologies if you already mentioned it, but out of curiosity, I wanted to know which type of cases or subject matters cannot be settled by arbitration from the
So, starting, do you mean which part of disputes, which disputes go to arbitration, or which powers being expired by?
which actually the contrary, which matters cannot be settled by arbitration.
Okay, so the starting point is that all matters can go to arbitration. Any dispute can go to arbitration, because we're talking about party autonomy. Parties decide they want their dispute to arbitration, they can take it to arbitration. So that's the starting point. Carved out of that, there are exceptions to that. And the exceptions depend on which country you're talking about, because different countries have different rules about what falls within these exceptions. But generally speaking, there are matters that are of general public interest, or the matters that involve vulnerable parties that the state wants to step in to protect. So, typically, family law matters. Not all family law matters, but a lot of family law matters cannot go to arbitration because they involve children. Criminal matters. The state has a public interest in ensuring that criminal matters, for example, which not just murder, that sort of stuff, but also fraud, has to go to public courts and not to arbitration. Some matters involving IP, which patents and that sort of thing. Some matters involving competition. That's a very broad generalization. Lots of IP disputes can go to arbitration. Some of them because they involve states. There are some matters which overlap between contract matters and statute matters. And sometimes the courts assert their primacy to hear the dispute. I'm doing a case at the moment where I'm sitting as an arbitrator where in a Singapore arbitration involving an Indian company, and the contract says certain matters involving running that company are decided in arbitration under the contract, but Indian law, the Companies Act, also says this stuff goes to an Indian court. And we as the tribunal said, yes, we can hear this, but we've had an injunction from the Indian courts to say, no, stop doing that because we want to decide whether we should hear it instead. So there's an overlap there. So yeah, family crime, and there's probably some others as well. But that's the point. And as I said, it's different from different countries because they talk about, it's called arbitrability. Is the subject matter dispute arbitrable? Can it be referred to arbitration?
Doesn't tax come up in that category?
Tax is another one. Again, some tax disputes can go to arbitration, but generally speaking, tax is something that governments have great interest in. They want to get a tax, and therefore it has to go to the courts. Nothing else? Okay.
One slight point that you've got the last point there on the award. That is probably the end of the process for the arbitrators.
Yeah.
It's not the end of the process for you as a council.
No, I was the arbitrator in this case.
What?
I was an arbitrator.
Oh, you were an arbitrator.
So,
okay.
So the end of my job was when the award was issued.
Yeah.
An arbitrator, they lose their jurisdiction when the award is issued, because at that point, the dispute is over. You only get a jurisdiction out of your dispute. When there's an award, there's no more dispute. You can't do anything further. But you're right that the parties in that case, the council in that case, still has to do something with that award and to enforce it. And the losing party may have paid up. I don't know what happened. The losing party may have paid up, or they may have applied to enforce it somewhere.
But I think the point is, for the arbitrator, it's over, you've got the award, but for the parties, they want to be able to they want to monetize the award. Yes,
yeah.
they want to get something out of it. Otherwise, why have they done the whole thing in the first place? They don't want a nice legal document at the end of the day. Even if it's favourable, they want something to come out of it. So that's when your New York Convention kicks in, and you take the award to, or the council will take the award to a court, maybe in the United States, somewhere, in Switzerland. And try and get the award enforced.
Yeah.
But this is quite a hot topic these days because there's quite a lot of people who don't pay up. And so therefore you have to be, I think as a council, not an arbitrator, but as a council, you have to sort of get going to try and make sure that your client gets paid. You know, and it's not just governments that don't pay. I mean, a lot of parties don't resist the payment.
Yeah, I mean that's the point of the New York Convention, to enable enforcement of awards internationally. The other thing you can do with an award is sell the award. It's a market in awards. So you might.
At that point, you can sell the award, really like a market. You've got the award, legal document. Ben just saying you can sell it. You go.
Yeah, so let's say you're awarded $10 million and you recognise it's going to be difficult for you to enforce that. So you sell it to a specialist enforcement company who will then take on that enforcement process. Of course, you'll have to sell it at a discount. You might sell it for $5 million, but so you don't get the full amount, but you get ready cash. And the party who's bought it, they're looking to make a profit by enforcing it for more than $5 million. So that's where their profit comes. They might be able to get to 10 million. Yeah.
And so, I mean, Burford Capital is an
Yeah.
example of that. There are certain companies out there that do this. They go around trying to enforce it. Recently, they lost one, YPF, I think it was.
All right. Argentina.
It was in Argentina. Yes, there was a big loss because they were likely to make an awful lot of money, and the share price of this company that bought the award, the share price went down quite significantly. So that was just in the last week.
Okay.
So it looked like it was going to be a huge award.
Yeah.
And they were, I think it involved maybe Total. I'm not
yeah.
sure, but they had sold it. They had sold it to Burford. So that's something, it's a dimension, it's like a post-award world of enforcement of awards. I always find it interesting because if you meet at these conferences, people from, say, Cobre and Kim, these firms that specialize in enforcements, and you talk to them, it's a bit like talking to such people who've contributed to some of the John Grisham novels, because they're full of all sorts of tricks that they play to try and identify the people who have hidden away the money, and often they hide themselves. They just disappear. The money disappears, but they disappear too, just in case they might be subject to some proceedings. So these people, like detective agencies, they try and go and find those people in order to get the money. It can get very dramatic when they're searching around the world for the missing money and the missing litigant. These firms specialize in that sort of thing, and they work a lot with intelligence agencies and detective agencies and so on. But that's a post arbitration type scenario, but it's the scenario you get if you're a counsel and you've got your client and the client's saying, well, okay, what now? And as Ben was saying, that's not what the arbitrator needs to concern themselves about.
Yeah. And the famous case for enforcement and non-enforcement is the Yukos case. So Putin arrested one of the oligarchs in Russia and took away his company, a company called Yukos. Yukos was an oil company, lots of reserves, very valuable. The award, I think, was 52 billion or something like that. It was more than 50 billion, certainly. And that's such a huge amount of money that there's a lot of value in chasing that money down. Even if they get a small fraction of that money, they're going to make a lot of money out of it. And enforcement has been taking place all over the world in that case. The case the award was 2010 or 2008 or something, and they've been enforcing going on for years and years over that.
So the interest will be very significant on that amount of money. So they go around the world trying to identify Russian assets that can be impounded or taken in a particular jurisdiction, aeroplanes or whatever it is, Russian embassy building maybe, the Russian embassy that the Russian government tries to sell. Immediately you get to hear about that, you can say, okay, we will put some kind of attachment to it and by the local court and try and get the property, resell it and keep the money, that sort of thing. But anyway.
Moving on, you can tell I just go over.
I'm sorry, one little point, Ben. I'm sorry to keep interrupting a very rude person, but the other thing that occurs to me was you can challenge an award.
Yep.
We haven't mentioned anything about that. That you can get the award made. there's the enforcement issue, but there's also a challenge. You can challenge that award. So is this something that you are bothered about as an arbitrator, the prospect that your award might be challenged?
Yes, but only in the sense that it's embarrassing. I have had awards that are challenged, but you're still not involved in the case, so you're out of it by that stage.
Sure.
You don't want your name dragged through the law reports, and
Right.
criticised for what you've been doing, especially when you don't have an opportunity to comment on it.
Yes.
So that's another reason why awards are very long, because you want to make sure that everything is covered and they can't be criticised.
Yes. And with ICSID cases, where the chances of that being challenged are small. Instead, the intention is to try and annul the award.
Well, that's because it's a different system. So commercial arbitrations are seated somewhere. I mentioned this earlier. They are seated in a particular country and therefore subject to the supervision of a particular national court. And you challenge it within that national court. I have written a book about challenges. I mean, I did all the sections about challenging arbitration awards there. ICSID doesn't have a seat. ICSID is an international system where you have no court to challenge it in. Instead, you can apply to annul it within the ICSID system. And that involves, instead of going to a court, you appoint another arbitral tribunal to hear the annulment application arising out of the ICSID award. So you can challenge it, but it's called annulment in the ICSID system, not challenge.
And normally, if you were challenging it, you challenge it through a court.
Yes, so normal commercial arbitration, it's through the court, and there's certain defined ways you can challenge, limited ways you can challenge an arbitration award.
And I just realised, with a Nigerian component in the class, the famous challenge to the
P&ID
case, which Nigeria lost in the arbitration, and then Nigeria lost. Yes, it lost, but it was challenged.
Was challenged, yeah.
And it was successful.
Yes, so
Nigeria won the challenge.
So that's a very interesting case because it shows what can happen. So the contract, it was all about flare gas off Nigerian oil fields. So when an oil field reservoir is found and they drill down into it, they always find gas as well. Not talking about gas fields, talking about the little layer of gas at the top of an oil field. Typically what they do is they flare it off, they just burn it off before they get to the oil. This contract involved going to the Nigerian government and saying, all that gas you're burning off, instead of burning it off, we will build this system whereby the gas is used to generate power, the power station. Brilliant idea. Good, it's a good thing to be doing. However, the party who was planning to do this, there were some Irish builders who had no experience in building these things, and as it turned out, there was a lot of money changing hands with the Nigerian officials. It was an example of corruption, and also this thing was never built. And because the government changed in Nigeria, the new government cancelled the contract. At that point, the Irish builder, actually the main Irish builder died by this point, but his company sued the Nigerian government I think it was the state actually. And they obtained an award, I think it was 8 billion, I can't remember, the Nigerians might remember myself. Now, the question was, could you challenge it on the basis that the original contract was corrupt? The answer is probably no, because a challenge it's about the procedure in the arbitration, not what happened in the contract itself. They may have subsequently been able to resist enforcement later on, but they couldn't challenge just because the original contract was corrupt. because that's regarded as issue for the arbitrators. However, what had turned out was that the witnesses in the case had been bribed. And
The witnesses have been
witnesses had been bribed. And also, I think some of the people representing the Nigerian government had been bribed as well. So the whole process was tainted with bribery, and therefore the award was set aside.
Yeah, and it was Justice Robin
Knowles,
Knowles, I think,
Knowles,
that was leading on that. So you can actually have a successful challenge in spectacular cases like that, where the amount of the arbitral award is was very high, and the process appeared to be unfair.
Yeah.
Very unfair. Okay, I'm sorry.
Fine.
Go ahead.
Okay, I've got my last half hour, so sorry. Another quick case study. I was an arbitrator here. This was an application for interim measures, application for an injunction. I was the arbitrator. It was under the SAC rules. This was an example where I was talking to someone earlier about an application for freezing order to an arbitrator. Typically, you would go apply to freeze assets to a court because a court can act much more quickly than an arbitrator. A court can also hear applications done without giving notice to the other side, whereas an arbitrator can only hear on notice applications where you give notice to the other side. You don't want to give notice sometimes for a freezing order because if you give notice, the other side will just move the assets before the award is issued. This is a very special case, though, that the money had already been frozen by an administrative process within a bank, and so what the claimant was doing was looking for was a continuation of the freezing that was already in place, and they applied for it on the 9th of May. My birthday is on the 13th of May, by the way, so the crucial piece of information as we go through this. 9th of May. They applied for it, which I think was the Friday, and we got written submissions on the Sunday, the 11th of May. The 11th of May was the Saturday because the hearing was, on the 14th of May, that was a Monday. We had further written submissions the Monday afternoon. The hearing took place on the Monday evening, and I issued the award on the Wednesday. I actually wrote it on the Tuesday, but the SAC was slow in commenting on it, which is why it came out on the Wednesday. And so that's an example of an interim application process within arbitration. Courts can do it quicker than that because they are set up to do these things, and they will have a judge on call all times of the day and night within the English system to hear emergency applications. And as I say, they can hear it on a without notice basis. But arbitrators can also move relatively quickly if they have to issue an injunction. Okay, so I was going to move on now and talk about the CIARB. And then I do have some discussion points at the end, and hopefully we can cover it all. But equally, if you want to talk about something or want me to answer other questions, I'm happy to do that as well. Just very quickly about the CIARB. The CIARB is the leading ADR organization in the world. You remember what ADR means? Alternative dispute resolution, amicable dispute resolution. Covers all these methods which are not courts. So it covers arbitration, mediation, adjudication, etc., etc. It's founded in 1915. And we have 18,000 members, 95 branches and chapters throughout the world. Our focus is on education and training and membership. So we don't run arbitrations. We do have some rules. We do appoint some arbitrators, but we're not like the London Court of International Arbitration or the ICC or the American Arbitration Association, who all they do is run arbitrations. What we do is train arbitrators, train mediators. And we also offer networking events and a whole bunch of things to support our members, including practice guidelines. There's some very good guidelines on the CIARB website. For example, there's one about AI, which was issued last year. We publish an academic journal. We represent our members in various meetings, such as meetings at the UN. We have a disciplinary panel if people have not behaved themselves. And as I said, we do appoint some arbitrators. So we cover the whole range of things within the arbitration industry.
And then there's quite a lot of people, I guess, who would be asking the question, how would you get started as an arbitrator? Especially if you're junior, you're reasonably young, you're just getting started, you're very, very enthusiastic, and it may look like a mountain that you're faced with. How do you climb that mountain? Do you have any suggestions?
So within our levels of membership do offer a career path of sorts in arbitration. So a student member is free. So if you want to sign up, then sign up straight away. That gives you access to the events, go along and speak to people who do arbitration. Associate member, you do have to start paying at that point. But that's typically people who are young lawyers who already work. Members are more senior lawyers who've had a few years' experience doing arbitration. Our fellows are people who've been trained to sit as an arbitrator. So we train people to be an arbitrator, and they are the fellows. They may not actually have yet sat as an arbitrator, but they're trained to do it. And people who are chartered arbitrators are people who have lots of experience of sitting as an arbitrator. So I am a chartered arbitrator, by way of example. When I was at Queen Mary in 2003, I became a student member of the CIARB. That was the start of my arbitration CIARB journey, and now I'm the chair of the Board of Trustees. So I've gone all the way through the process.
So there you are, some of you, if you're interested, you always go for a student membership. It doesn't cost anything.
It's free. Yeah, student membership is free, but only while you're a student. So.
And it's a very international organisation, by the way. Unlike, I mean, I don't think maybe it's fair to say London Court of International Arbitration is something different.
It's not a membership organisation.
It's very English, it seems to me. Is that, I think you would say no, it isn't.
Yeah.
But
yeah, I mean, there isn't really an equivalent membership organisation in the UK. On the other hand, in Singapore, you have the Chartered Institute of Arbitrators, but you also have the Singapore Institute of Arbitrators, and that's a very Singapore institution.
Right.
And that's a membership organisation for people who live and work in Singapore.
And an advantage is you get to meet people from lots of different countries who have a similar interest in arbitration. And this networking is very, very useful. Not just at the student level, but at all levels, that networking. They have an organisation called Arbitral Women, which I know isn't part of that, but it's an attempt of female arbitrators to work together, to network, and to share contacts and things like that. It's very successful, a kind of niche organisation. So these are bodies, when you've got an associate, you're allowed to call yourself associate of
ACI, yeah. ACIR.
Letters after your name.
Yeah.
And the same with fellow and member and so on. You get sort of A, Chartered Institute, M and an F. Chartered Institute, Chartered Status is something rather different.
CIARB.
CIARB, is that right? CIARB. So how many arbitrations do you have to have done for that? Was there no limit?
I can't remember what the number is that. It used to be 5, but it's also under a point system, so it had to be 5 types of arbitration, with involving hearings, involving writing awards, etc., etc. So in order to get that, very broadly speaking, you probably have to have done 5 to 10 arbitrations.
Yeah, sure. Okay, good. So there you are, the Chartered Institute of Arbitrators. Worth knowing that it exists because their offices are where? In the Bloomsbury area, is it?
Yeah, Holborn. Well, near near Lincoln's Inn Fields.
So keep that in mind. They do have events like lectures and so on that are that you can go along to if you're a student. I know some of our students have gone along. The one I went to the last time, Mohammed El Mahad, I think you were at that one as well. That I noticed some Queen Mary students went to that one as well.
And in January, I did a session on careers in arbitration.
Yes. On green arbitration.
No, careers. careers
Careers arbitration.
in arbitration. It was mainly for students. It was done
Ah,
for ELSA, the European Law Students Association.
Oh, I've heard of that, yeah.
And we talked about the ways to get into arbitration and getting jobs in arbitration. And
Yes,
all
yes,
these things.
yes. Yeah, good, good, good. Do you have any questions?
I've got a few slides about scenarios to talk through.
Good, please go on, please go on.
Sorry, I didn't. Ben, I didn't have any questions about the CIR.
Any questions? We're getting a little bit towards the end, so I think there's possibly a little bit of fatigue setting in because of the time of the day. But if so, that's perfectly forgivable. You'll understand that we're not fatigued, we're full of energy. Because we're doing what we're here for. All right. Okay, it seems that no questions about the Chartered Institute. You can study. Did you have a question? No. Okay. All right.
And I've got some scenarios we can run through as well, just to finish up within the last 20 minutes. These are all cases that I've done, actually. So they are true to life. And the first one is, and you don't need to know about arbitration law in order to answer these questions. They're really common sense laws. But they illustrate the practical issues that arise in arbitration. I mean, they have arisen because they happen to me. So this case was a case that I was sitting as the presiding arbitrator, so the chair of the tribunal. It was in Hong Kong, and we had a procedural hearing. And after the procedural hearing had been completed, so this is the beginning of the process, we'd set a timetable at this procedural hearing. One of the arbitrators, we left the arbitration, the hearing room, and one of the arbitrators turned to me and said, "Oh, I've just realized that the lawyer represented the claimant. I'm working with another case." So he was a solicitor in Hong Kong, and he was instructing this barrister on another case. And I said, "Oh, yeah, that's very interesting." And then he said, "Oh, and I've just realized the same lawyer is representing my son in a personal injury matter." Now, what do you think what went through my head at that point? Sorry?
The arbitrator could recuse himself, basically.
But why?
Because first of all, the claimant's counsel will be impacting his son's matter. So there's a personal profit, right? The personal relationship is an impact. In the second scenario, where
So the same scenario, it's the same thing. yeah, sorry, so the second point, yeah.
exactly, there's professionally the bias would be there towards the counsel. There would be a better understanding towards the counsel. He might be more thorough with his submissions and not with the other counsels, because there will be a lot of unnecessary bias. For the second situation, definitely requisition is the way to go. The first stance, disputable.
Yes, very well. Very well done. So the point here is that arbitrators have to be independent and free of bias. And you're meant to declare it actually at the outset and say if you've got any conflict of interest. But this arbitrator failed to do so. And it turned out that he did have some relationship with the lawyers representing one of the parties, which could affect his independence in the case. And actually, he could have been challenged by the other side. His appointment could have been challenged because he wasn't independent. We had a conversation, and he resigned from the tribunal later that day. So what I did was I encouraged him to resign. Okay, thank you. Here's another one. I was the presiding arbitrator. This was in Singapore. We had an arbitration in Singapore. The claimant, it was a shipping matter. The claimant, who was, I think, Indonesian, filed a request for arbitration, and the respondent, which was an Indian company, filed an answer. So they responded to the request for arbitration. The respondent then didn't participate at all. They stopped participating. We couldn't get hold of them. We wrote to them, and they didn't reply. And during that time, the claimant went ahead and filed the witness evidence. And we also had a hearing. The three of us, the three arbitrators sat there. We heard the arguments from the claimant. The day after we finished the hearing, the respondent wrote to us and said, can we take part now? They applied for amendment of the procedural timetable so that he could file submissions. So what went through my head and what did I do?
I think you can still allow him to bring in his submissions because it's still the award has been given yet. But I don't know how many costs will be granted for the delay and all that because he was notified of the arbitral proceedings. But I believe he can still be here prior to the final award.
And what would be the implications of that? I mean, what would, in practice, how would that work? We've already had the hearing, so what would we do? I'll tell you what I actually did in a moment, but no, you're right. Sorry, but keep on going. So if they filed submissions, then what would happen next?
Once they file submissions.
Yeah, if the respondent filed submissions.
Okay, the claimants will have to look at their submissions.
Yeah, and then we would have to have
Yeah.
another hearing. We'd then have another hearing. We'd have to run the whole arbitration again. So you're right, that's one possibility. I won't tell you yet what happened, but you're right, that's one possibility. Does anyone have any other views? What else could happen here? I know you're dying to say something here. So we have the example here of someone who's willing to be slow. I don't mean that in a rude way. Willing to take lots of time here, spread out the whole process over maybe another year or so, hearing more arguments, repeating the whole hearing. Anyone take another view of that? Yep.
Just pause an ex parte order and forget about it.
Well, it wouldn't be ex parte. You'd just say, the respondent, you've had your chance. We wrote to you. You had the opportunity. You knew what the timetable was. You missed your chance. And therefore, we don't just, we're not here just for the respondent. We're also here for the claimant. And the claimant is going to suffer by you not complying with the tribunal. So we could say, sorry, but we're proceeding. So that is the options. You either hear these submissions and repeat the whole thing, or you could say, no, we're just going to crack on. Now, maybe you've seen enough of me now to the last hour and a half, so you guess what I did. But actually, we did what this lady was saying, that we heard their submissions and let them back in. But we didn't repeat the hearing. We just heard their submissions about why they'd been so late. And although they had lots of goes at it, they didn't just file it once, they filed several submissions about this. Eventually we got to the point where we said enough was enough, we're issuing this award. So we sort of did a mixture of the two of what you said. We were very careful in that case because we were aware that if we didn't do this, then our award might not be enforceable in India. So that's one of the reasons why
It was in India.
we were going to find in favour of the claimant, and we knew that they were going to have to issue it, enforce it in India. And we also knew that the respondent was just playing this game because he wanted to resist enforcement later on.
That would be my first response to that last bullet point, that the respondent wasn't serious. I'd be, and I think that the next point is, even if it isn't serious, how do you respond to it? And you responded by basically giving them some slack and allowing them to make the submissions.
And it shows the benefit of being experienced yourself and spotting the games people play. what's written on the page is one thing, rules are one thing, but what happens in practice and how people try and manipulate you is something else. I got one more. This is not a. What happened during a hearing, but in this case, the presiding arbitrator, they start an arbitration. The arbitration clause said the disputes are to be resolved by arbitration before the SIAC in accordance with the rules of the ICC. This is a bit of a technical question, I must say. We're going a bit beyond the common sense. But there is a general point here that people might still be able to pick up on. Any views?
This is an important objection because what they're basically saying, implying is that the tribunal has no jurisdiction. So it doesn't matter what the tribunal thinks about the substance, it doesn't have a right to hear the case. That's what they're saying. So that jurisdictional objection is quite a powerful one to make for the objecting party. And so they're basically saying, given what the wording there, this tribunal has no jurisdiction. Is that all right?
Yeah, but what was the argument? Please, at the back.
Yeah, so the problem I see is that the Singapore International Arbitration Center probably will not conduct an arbitration under the rules of the ICC, if I'm not wrong.
Yeah.
So while they haven't really chosen a center, that's up for debate. Both parties have agreed to the arbitration, so the clause is still workable. But you could go to a court and they could appoint an arbitrator or have an ad hoc arbitration. It's just that it's foggy on how the arbitration will be carried out. So
Exactly.
some tribunals have jurisdiction, but you don't know which tribunal.
Exactly. So what we're talking about here is they've mixed things up. They've written a clause setting out their dispute resolution method, but they've confused it. Whoever has written this has confused it. They're saying, we want to have an arbitration in Singapore, but we want to use the rules from somewhere else. And they mixed it up. Now, Singapore being Singapore, the Singapore SIAC said, sure, no problem. We're very flexible, we can do these things. The ICC, which is based in France, and they're very French about it, got very upset by this and said, no, you cannot have an ICC arbitration with the SIAC rules. But yeah, that's the point. The people make mistakes in drafting contracts, and people come up with all sorts of odd things. And you're right, Peter, that there could have been a jurisdictional issues if the SIAC hadn't been so flexible.
Yes.
They could have said this doesn't work at all, and therefore you cannot have the arbitration.
And it's a very successful arbitration center,
Yeah.
the Singapore one. There are many, just my little comment here before we come to your question. Ben mentioned that there are lots of arbitration centers. They're all proliferating all over the place at the moment. There's so many of them. There's one in Scotland, there's one in Armenia, a very new one. Many of them. But there are only a few that are very successful. Is that not right? And Singapore is one of them. And another one is London, the London Court of International Arbitration. So what else? Which other ones would you say were?
Paris, Stockholm,
Paris.
New York, Vienna,
Paris.
Hong Kong. Yeah, those are them.
Not many. Paris and the Stockholm Centre for Arbitration Institute of the Stockholm Chamber of Commerce. They used to get a lot of East European cases. They deliberately cultivated that sort of regional direction. Then they tried to get Chinese cases as well. I think that was less successful. And I think since in the last few years they've been much less successful with East European cases.
Russian cases.
Russia.
Yeah.
Yeah, they still get Russia.
Yeah. Less of the Hungarian,
Right.
Russian.
Yeah, okay. So they try and get out to get business, so that they sort of increase their importance as an arbitration centre. So it's a lot of competition amongst these different centres. Sorry, there was a question you wanted to ask.
Yeah, sorry, I just don't get why is it problematic when I only choose the center like this. Isn't it
Yeah, well, this is a difficult question because it's really for people who know a lot about arbitration already. The clause says you have to resolve the arbitration before one arbitration institution, but use the rules of another arbitration institution and mix them together. Let's take a better example, perhaps. What if they said, we want you to resolve this dispute in the court of Bahrain, for example, but use the rules of court of Colombia and mix them together. And the Bahraini judge will say, yeah, this doesn't work, we can't use this.
Just my maybe the parties might be comfortable with the center because they think maybe they're more neutral or.
I can tell you why they did it. The ICC is very expensive, and the SAIC is cheaper.
That's another reason. So I don't think actually, I'm not sure how in practice this can cause an issue in the contract if like a center is using the rules.
Yeah. The issue is, can it actually work? Well, I'll tell you why there are problems. The ICC rules have certain provisions in them which say if there's a gap, you refer to the ICC to resolve. For example, appointment of arbitrators. There's also some things about when you write the award, it goes to the ICC to deal with. But here, you're taking the ICC out of the equation. You're just using the ICC rules, but without the ICC. And so how does that actually work when you don't have the ICC involved? If the ICC rules say you have to appoint an arbitrator by asking the ICC to appoint one, but you don't want to ask the ICC, then how are you going to do that?
But like, is it, I mean, can really the arbitration center in Singapore approve it, or is it that a jurisdictional matter that it cannot be?
It's not actually a jurisdictional matter. It's a question of whether the clause is workable or not, which is slightly different from jurisdiction. Under the New York Convention, you say that an arbitration award is valid, and you have to uphold an arbitration agreement unless it is null and void, inoperative, or incapable of being performed. This is potentially incapable of being performed because you're trying to apply the ICC rules without the ICC. So it's slightly different from the jurisdictional question. Could be an arbitration clause which cannot be operated. In practice, sorry?
So the clause would be considered invalid in this case?
Well, we wouldn't say, incapable of being performed. Under arbitration law, you talk about something being valid because of a legal point, like the party hasn't had proper authority to sign the arbitration agreement. But you talk about something being incapable of being performed if it's just impractical. In practice, you cannot do it. That takes me to 3 minutes to 9. So I just had some Q&A, but
Any last questions?
final questions.
I just wanted to find out, since the essence of arbitration, it's basically one of the major points is to make the dispute resolution faster, to complete speedily. So that's I just wanted to find out, like, in terms of finality, is there any like measures to avoid people from keep getting to avoid people from criticizing or trying to set aside arbitral awards? Because if you get an award and then someone goes to court with it, it defeats the essence of
So the first point is that it's a myth to say that arbitration is quicker and cheaper than court, or rather, it depends what courts you're comparing to. Some arbitration is a lot quicker than some courts, but a lot slower than other courts. So it depends what you're comparing. Arbitration is final in the sense that you cannot appeal an arbitration award on the merits, but you can challenge if there's something gone wrong with the arbitration process. And that's what you're talking about there, that someone may try to challenge the arbitration award if something's gone wrong with the process. And if the court that hears that application is sophisticated and knows about arbitration, and generally speaking, they will resist. They will chuck out the challenge. The English courts, most challenges go to the commercial courts. If you challenge an arbitration award in England, you've got there's a success rate of less than 10%. Somewhere around 5 to 10% of challenges are successful. So actually what you end up doing is just wasting money to challenge. Other courts is different. Other courts, may use challenges technically and are much more successful in challenging the awards.